Good morning, everyone. Welcome to the February 17th, 2026 meeting of the Virginia Gas and Oil Board. This time, I would remind everyone to please silence your cell phones as these recordings are being recorded. These proceedings are being recorded. If anyone needs to take a cell phone call, please go out into the hallway. For those of you online with us today, I remind you to remain muted unless you're engaged with the board, and also to engage your video if you're communicating with the board during any of the items on today's agenda. This time, we'll ask the board members to introduce themselves here that are present today.
Patrick Owens, public member, and Mr. Chairman. Conflict to declare items 3 through 8. I have a business interest with one of the interested parties. Items.
Dennis Sutherland, co-representative.
Gus Jansen, I'm a public member and also serving as the chairman of the board.
Lawton Mullins, gas industry representative. Mr. Chairman, I will also be abstaining items 3 through 8 due to a business relationship with parties involved today.
Mary Gibson, public member.
Willie Cochran, Virginia.
Thank you, everyone. The first item on our agenda today is to review the remote attendance resolution for the board members that will be attending the meeting remotely. We have Mr. Harris on the line today. Is that correct, Mr. Harris?
Yes, I'm here.
Thank you. So I have a motion to allow participation remotely by Mr. Harris due to the fact that he has a temporary medical condition preventing his physical attendance. Do I have a motion?
So moved.
Do I have a second?
Second.
Motion second. All those in favor say aye. Aye. Any opposed? Have none. So, Mr. Harris, you're approved to participate in today's proceedings.
Thank you. Let me just introduce myself. I'm Bill Harris, a public member.
Thank you. The next item on the agenda, the board will receive public comments. Ms. Gilmer, do we have anybody signed up for public comment today? Is there anyone in the audience or online today who wishes to address the board in the public comment section? Hearing none, we'll move forward. I think we have several items on the agenda today that have been continued multiple times. At this point in time, we have had a motion last month to continue these items as parties were negotiating a settlement. The parties come forward and bring us up to date on where we are on their settlement.
Mr. Chairman,
Yes, sir. Mr. Schwartz.
we exchanged proposals. Well, let me go all the way back. I think we had called E36 at the last meeting, and in the process of beginning to discuss that, there was an interest expressed in settlement. The lawyers, with some input from the chairman, I believe, reached a tentative agreement, at least an agreement that I believe we were the lawyers were going to recommend to their respective clients. Obviously, it was subject to that approval. We took it back to our clients. The lawyers negotiated occasionally during the time between the last hearing and this hearing. We were unable to reach an agreement. And so we're going to need to have hearings today. I will tell you that on reflection, let me get a shot of something up here for us to look at. Let's see here. Can everybody see that screen or that plat on your screen?
Not yet. We give it a second.
Have you got it now?
No, we can't see it, Mark.
Okay, Kelly, can you bring up the plat for the, that's just weird, you can't see that. Let me try one more time. Okay, could you bring up the plat for the FRO that has the various tracks in it, including the 1 acre tract? And if you can do that, that would be great. So without the map, let me just kind of refresh everybody's recollection. With regard to E36, there is 1.05 acres of E36 that is in the 19 East panel. And the idea was that we could cut a deal or an agreement with that 1 acre tract, which Buchanan owns and Diversified leases, and not be required to pool E36. And that was the agreement that we were going to take to our clients, recommend to them, and hopefully work that out. Ultimately, as I already indicated, we were unable to settle that issue. We have discussed it. That will definitely work, Kelly. Can the board members see this?
Yes.
Okay, and if you go to E36, there is a where the word 19 East head development is, Kelly's got her cursor there. There is a 1.05 acre tract that is in E36 and catches the end of 19 East before a solid block of coal. And that's the acre that we were talking about. On reflection, even though we haven't been able to reach an agreement with regard to that, we have decided that rather than spend several hours potentially today fighting about an acre in E36, we're going to withdraw that petition. We'll resolve this or deal with it going forward on some other basis, but we'd rather not spend a couple hours today fighting about that acre and would withdraw our petition with regard to E36, obviously without prejudice, but just withdraw it. We don't have to hear it today. And then we could address F36, E37, and E38.
Okay. Thank you, Mr. Stewart. Do you have anything to add on the settlement negotiations?
No, sir.
Either Mr. Pruitt, do you need to come in? And with this development that we're withdrawing the petition for E36, we did have a motion still on the table that was not addressed last month by Diversified to dismiss, so that motion becomes moot, so we can move on from that.
Agreed.
And so the other motions I think we've addressed, so everything else should be good to move forward on, correct?
Yes, sir.
So at this point in time, we're ready to move forward with item number 4, which will begin the formal hearings for these petitions. So I'll call out item number 4, a petition for Pocahontas Gas LLC for pooling under liquid coal methane field 2, unit E36, docket number VGOB S205-317. All parties who wish to address this item, please come forward.
Mark Schwartz and Kelly Barry.
Mary, do you swear or affirm your testimony is the truth, the whole truth, and nothing but the truth? Muted. Kelly.
Sorry, I do.
Before we go any further, I guess we'll conduct this hearing under the same format that we did the original formal hearing. So we'll have the petitioner go first, provide his, any other witnesses he wishes to present. I don't know if you have other witnesses you need to swear at this time, Mr. Schwartz. Diversified and Pocahontas will have a chance to cross-examine those witnesses. Then we'll come back to you again, Mr. Schwartz, for any final follow-up.
Understood. Okay. Kelly,
Mr. Chairman,
But do we have other witnesses that you need to swear in before we move forward?
I think we have, Josh, are you online?
Yes, I am.
Can we see you so we can get you under oath?
Yeah, cameras should be initiating here.
Okay. There we go. Josh Ball,
Mr. Ball, do you swear and affirm that your testimony is the truth, the whole truth, and nothing but the truth?
Yes, I do.
and then Greg, Braden. Greg, are you online as well?
I'm here.
Okay, let's
Pulling up.
get a look at you if we can.
Here I am.
Mr. Braden, do you swear or affirm that your testimony is the truth, the whole truth, and nothing but the truth?
Yes.
And then lastly, Mr. Chairman, Jonathan Belcher. Jonathan, are you online?
Yes, I am.
Okay, can you turn your camera on so we can see you?
Mr. Belcher, do you swear or affirm that your testimony is the truth, the whole truth, and nothing but the truth?
I do.
And that would be my witnesses, Mr. Chairman.
Thank you. Mr. Street, Mr. Pruitt, will you have any witnesses that will be testifying on these petitions?
Yes,
To bring those people forward also at this time?
yes, Mr. Chairman. Jason Davidson, who will testify for Buchanan Energy.
Go ahead and swear in Mr. Davidson.
Mr. Davidson, testimony is the truth, the whole truth, and nothing but the truth.
I do. I have two witnesses, Mr. Chairman. Probably still living.
May get up here where we can hear you on the microphone, please.
Yeah, I'll let them.
And what was the other name?
Travis
Cook.
Travis Cook. Okay, Mr. Cook, Mr. Stillwell, do you swear or affirm that your testimony is the truth, the whole truth, and nothing but the truth?
Yes. Yes.
Okay, thank you, everyone. You may proceed, Mr. Schwartz.
Thank you. Kelly, could you state your full name for us, please?
Kelly Berry.
Who do you work for?
I work for CNX Gas Company LLC, appearing on behalf of their subsidiary Pocahontas Gas LLC.
What do you do for them?
I am a senior analyst of land records and division of interest.
Did you prepare the application that we're discussing today and the exhibits thereto?
Yes, I did.
Okay. Could you bring that map back up that you had a moment ago for us? Okay, and this to sort of tell us where we are at the moment. We have in the E row, we have withdrawn our application for E36, so we're not going to be addressing that. We have a pooling application filed for E37, which will also be on today's docket, and we're talking about E38 currently, correct?
That's correct.
And do we have voluntary units in this row, in the E row?
Yes, we do. Units E39 and E40.
And by voluntary units, we mean we Pocahontas Gas LLC controls by lease or ownership 100% of the coal bed methane interest in both of those units.
That's correct.
Okay. With regard to this application today, what did you do to tell people that we were going to have a hearing today?
We mailed a copy of the petition and application to all of the respondents by certified mail with return receipt requested. And we also published in the Bluefield Daily Telegraph.
Did you provide the division with your certifications with regard to mailing?
Yes.
And did you also provide the newspaper certification with regard to publication?
Yes.
Do you want to add any people as respondents today?
No.
Do you want to dismiss any people as respondents?
No,
And there are only 3 respondents which are identified in both your application and your notice, correct?
that's correct.
And that's Buchanan Energy, Diversified Production, and Appalachian Energy.
Yes, that's correct.
Okay. The applicant is who?
Pocahontas Gas LLC.
Okay. And is Pocahontas Gas LLC a Virginia operator?
Yes,
Is it authorized to do business in the Commonwealth?
yes,
Has it registered with the Department of Energy, Division of Gas and Oil?
yes,
And does it have a blanket bond on file?
yes.
Okay. With regard to this application, what rules are we applying for?
We are applying for pooling under the Oakwood 2 rules.
And that applies to gob gas wells, correct?
That's correct.
Okay. Working through the application and notice, you identified the type of wells in both as what kind of wells?
Coal bed methane gob wells.
Okay. And with regard to costs, have you provided a cost estimate?
Yes, we have.
And in your notice and application, what is the number that you've provided?
The estimated cost allocation for the 19 East panel is $499,093.70.
Okay. And that would be the number that people would use to multiply by their division of interest to come up with a dollar figure if they wanted to participate.
Yes, that's correct.
Okay. At PDF page 5, you provided a plat,
Yes,
and it's a plat of an 80-acre Oakwood unit,
yes, that's correct.
followed by tract identifications.
Yes,
And then Exhibit B is what?
Exhibit B lists all of the owners or claimants in the unit.
We come down to Exhibit B3. You will find, let me see here at page, looks like PDF page 11 is your Exhibit B3.
Yes,
And in that exhibit, you have listed the respondents, correct?
yes.
And you've given us 2 percentages. What are those percentages?
Those percentages reflect the percentage of those tracts that bear to the 80-acre unit and the percentage that those tracts bear to the 19 East panel.
There's also another panel that ultimately might be a projection that ultimately might be affected by this unit. Is that correct?
Yes, that would be the 20 East panel.
Okay, and we haven't included that at this time.
Not at this time,
Why not?
because it is more than 2 years down the road, and we don't have a good, solid estimate of timing to know when that mining might occur for 20 East panel. So we would bring this pooling back before the board in advance of that when we are made aware of that timing from Coronado.
And this is an issue that Mr. Ball has addressed with Coronado, correct?
Yes,
And he'll be able to tell us more about that.
that's correct.
Okay. Working through your application here, you have at page number 12, you've provided us with an estimate of allowable costs, correct?
Yes,
And how many wells in 19 East are we estimating?
14 wells.
And the average cost?
The average cost for each gob well is estimated at $753,344.
And that number comes from Mr. Ball, and he'll be testifying today as well.
That's
Correct?
correct.
Okay.
Yes,
With regard to the costs allocable to this unit that we're talking about right now, the E38 unit, that's the total shown at the bottom and highlighted in yellow.
yes, it is.
Okay. And then the next page, which is PDF page 13, we'll be talking to Mr. Ball about that, but that's his estimate.
Yes, it is.
Then we have, as required, we have a map of the unit again, but we have put projections with regard to the 20 East development, and the 20 East panel obviously would be above that, which we have not mapped.
That's correct.
And we've provided a proposed order. Okay.
Yes.
Going back to exhibit B3, page 11, what percentage of the coal bed methane interests in this unit has Pocahontas been able to either lease or does it own?
84.9%.
Okay. And the outstanding percentage, which we do not own or control by lease, is what?
15.1%.
That's what you're showing on exhibit B3, correct?
Yes, that's correct.
Okay. We have no escrow requirement here.
There is no escrow requirement.
Is it your opinion that, let's strike that. What lease terms are you proposing that the board use to put in any pooling order that it might issue?
That would be a value of $5 per acre per year for a 5-year paid up lease and a 12.5% royalty interest.
Also known as a 1/8 royalty.
Yes,
Okay. Is it your opinion that if you combine a pooling order with the interest that you acquired by lease or ownership, that the correlative rights of all owners of coal bed methane will be protected
yes,
and the operator would be able to pay them?
yes.
Okay. Is this development that's proposed for F38 consistent with the rules, the Oakwood 2 rules for the development of unsealed gob gas?
Objection.
Yes, it is.
Ask for a legal conclusion.
Sorry, I didn't get you said that.
Can you speak up?
Objection calls for legal conclusion.
Did you hear the objection, Mr. Schwartz?
Right. I mean, her job is to comply with your rules in terms of what is supposed to be in pooling applications and exhibits. Her job is to comply with the requirements of your rules with regard to the field. I understand what he's saying, but the fact that, lay people read rules and statutes and use them in their jobs doesn't mean they can't offer opinions as to whether or not they believe they have addressed the issues required.
Thank you, Mr. Schwartz. Does the board have any questions on this objection? Do you have a motion to sustain or overrule the objection? I'll make the motion to overrule the objection. Do I have a second?
Second.
Have a motion and second. Do I have a vote for everyone in favor of overrule the objection, say aye. Aye. Any
Aye.
opposed?
Abstain.
Okay, you may proceed, Mr. Schwartz.
Thank you. think that is all that I have of Kelly at this point.
Okay, thank you. Mr. Street or Mr. Pruitt, if you have questions?
This is Tom Pruitt for Buchanan Energy. I have a few questions. Of Ms. Berry, Mr. Chairman. Ms. Berry, you are the senior land analyst, if I heard correctly, and some of the questions I'll ask you today, we've gone through before, but to get it on the record, would like to replow some old ground with you, May.
Yes, sir.
Pocahontas does not have any title, legal title or possessory rights over the Buchanan Energy gas, coal, or surface within their lease, do they?
No,
And you hesitated a moment because it was a long question. Let me break it down a little bit.
sure.
You don't have a deed or a lease.
No, we do not.
To recover. You have the right to drill vent wells for Coronado, the mining sublessee, correct?
Yes,
And so Pocahontas really is only a contractor for Coronado with regard to any drilling that might occur on Buchanan Energy's property. Is that right?
I'm going to object to this. How is this relevant to our application?
I think I can connect that up with the next question, if I may.
Proceed.
Am I correct that Pocahontas is only a contractor for Coronado to
I
drill
can't
a
speak to
ventilation
that.
well?
I can't speak to that relationship specifically.
This is not a vent well, is it?
Well, we don't have any wells currently shown proposed in this unit.
Well, any wells proposed in the 19 panel are gob wells. They're not vent wells, are they? They're
That's
designed
correct.
to produce gas, and this application is to produce gas. That, am I right?
Yes, sir.
So Pocahontas cannot, at this stage, cannot operate any gas well on Buchanan Energy's property as either a principal or lessee.
I'm going to object to that as irrelevant. She's just told you that we do not plan on drilling a well in that small tract. Kelly, can you put that map back up again?
She is. That's right.
Okay, there's a small tract highlighted in pink at the bottom of E37 and E38 that is within the E38 unit and also within the 19 East Tail development. And I believe you just told Mr. Pruitt that Pocahontas does not plan on drilling a well in that pink area. Is that correct?
That's correct. We don't have one proposed in that area.
Okay, that's the reason why I'm objecting as irrelevant.
And my response to that is,
Go ahead, Mr.
my response to that is the unit itself has wells in it, and this will be part of the 19 panel, which ties with the unit immediately below. Is that correct?
Let me step in here just a second. Again, we're here today for a pooling application. We're not here for permitting applications for wells. The wells themselves will be addressed on the permitting side for any wells proposed in those units going forward. Today, we're just addressing the pooling of the gas. So if you have questions regarding the pooling, we'll go forward. So I'd make the motion that we sustain the objection at this point to the board. Do we have a second to that motion? So a motion and a second. All those in favor of sustaining the objection, say aye.
Aye.
Any
Aye.
opposed?
Say
I'll go on if I may.
Okay.
If Pocahontas is successful in pooling this acreage, will Pocahontas honor the royalty payments under the Buchanan Energy lease with Diversified?
I'm going
The
to object
term-
to, I'm going to object to that. We don't have a lease with Buchanan. There's no
Not
proof.
not really saying they do. I'm asking the question we've asked all along, Mr. Chairman, and that is, will Pocahontas pay Buchanan in accordance with their lease term?
And I'm going to object to that because the way that would happen is if your lessee, Diversified, participates in this unit, Diversified, because it actually has a contract with your client, would be required to pay according to the terms of the lease. The only obligation that my client would have if this pooling application is granted by the board is to pay according to what the board orders us to pay, which is a 1/8 royalty pursuant to a board order.
And you see, Mr. Chairman, that's where we agree.
That answers your question. I think he answered your question right there, that he's paying you the 1/8 according to what the pooling order says. You
Right.
understand that? Correct? That's the answer.
I understand he's saying a 1/8 royalty.
That's the answer to your question.
Yes.
Okay, move on.
Mr. Chairman, let me direct the board's attention to 45.2/1620G, which basically says if there's an existing lease within a unit, there's a payment made, and I'll read this, any royalty or overriding royalty reserved in any lease that is deducted from a non-participating operator's share of production shall not be subject to charges for operating costs, but shall be separately calculated and paid to the royalty owner. Now, the whole rub here is not 1/8, it's the downstream deductions they're taking from our 1/8. And our lease specifically says there will be no downstream deductions. And so when Mr. Schwartz says,
I've got-
we'll pay
I'm sorry.
we'll pay you the 1/8, then under the board's forced pooling under the rule, that requirement to pay of 1/8 without deductions is not present. So if Buchanan Energy is forced under that rule, contrary to subsection G, then our effective 1/8 royalty is reduced by all these downstream deductions, and we make a lot less money. That's the rub here. That's the point of the question.
You want to respond to that, Mr. Schwartz?
My response is, if Diversified, you need to have this conversation with Diversified. I mean, Diversified needs to participate to protect you under the lease terms. It's up to Diversified. Diversified can choose to not participate and strand you, and will pay under the board's order. If you want to receive the benefits that you claim you're entitled to under your Diversified lease, you need to look them in the eye and say, you need to participate and pay us according to our agreement. I mean, this is not relevant. It's not our dispute. You know, this is between you and Diversified. We don't have a contract with you.
In response to that, I believe subsection G requires a direct payment to the royalty owner. And that direct payment is prior to any division between Diversified and Pocahontas on participation. So in essence, Pocahontas pays a portion.
Pocahontas would pay the royalty to Buchanan as required by the board order. We have to do that if this is pooled. And then you need to look at Diversified and say, you need to participate, because if you claim you're entitled to more than the board order gives you because you have a better lease than some other people might have, you need to take that up with Diversified.
And we maintain that the act protects our lease. And that's the only fair way to protect relative rights. If there's an existing lease in a panel, it needs to be protected. And of course,
So explain to me how you're not protected if you do participate. Are you protected if Diversified participates in the well? Do you believe that you're protected?
if Diversified participates in the well, or if Diversified participates in the well, then the payment doesn't come out of Diversified's pocket. It comes off the top directly to us. And then contrary to what CNX Pocahontas' position is, both parties are subject to a straight 1A without downstream charges.
We'd have to
And-
have a contract with you and we don't. I mean, that's, we're wasting a ton of time here. We do not have a contract with you about your acreage. The
That's a
only
very important
responsibility
point.
we're ever going to have is if the board pulls this and orders us to do something.
The very important
Okay.
point is they do not have a contract with us, but we have a contract that's being interfered with.
You also have the ability to negotiate a contract directly with Pocahontas, correct?
Yes,
But you have failed to do that.
we can't do that because of the terms of our lease. We have given our,
Diversified can negotiate that. Or explain that part to me.
well, they would have to have permission and could do that, and I think they have been attempting to do that.
So we'll move on from this, but I think I understand your point. We may need to have some legal understanding from an AG's office before we make a final decision. We can move on. We understand the concept here.
And the basis of our objection then is that the board cannot decide that private contract issue. Only a board can do. And that was the reason for the question.
Well, I need to respond to that. We're not going to get an order from this board that says your contract is good, bad, or indifferent. Your contract with Diversified is not even going to be mentioned in this order. Okay? I mean, if you want to argue about what Diversified should do if they participate or what happens if they don't, you need to argue with Diversified about that. The board is not going to interfere with your contract. It's not going to address your contract.
I think I've responded.
Okay, one final question for you, Mr. Thorpe. If Diversified elects to not participate, does that participation option defer to Buchanan if they would like to participate in the well? Do they have they have that opportunity if Diversified passes that to them?
I would certainly think so that they can protect themselves. I mean,
Do you have the right to participate also?
I'm not sure that we do.
Well, I think we've just clarified that for you right there. I think you do.
Because we have a contract and the contract has been,
Your contract with Diversified.
yes,
If Diversified does not wish to participate in the well, they can say, Buchanan Energy, you can participate on your behalf. You can do it yourself.
and that's the board's position on that.
Yes.
All right, thank you.
Anything else?
No, I think that's,
Do you have any questions, Rick?
I do.
This is for Ms. Berry, correct?
Yes, ma'am. Ms. Berry, good morning. Nice
Good morning.
to see you again. Following up briefly with what we just talked about, is it the position of Pocahontas Gas that if Diversified elects to participate or participate on a carried basis, that Pocahontas Gas is then going to pay a 1/8 interest royalty directly to Buchanan Energy? Is that what you're proposing to the board?
If Diversified were to participate on a carried basis,
Or on a participating operator basis?
well, there are differences in how royalty is addressed under those, if they participated, by paying their proportionate share, then the
Okay,
royalty.
let's take it separately then. If
Sure,
Diversified elects to be carried,
sure.
what, if any, payments will Pocahontas Gas be making directly to our lessor, Buchanan Energy?
The royalty in a carried participation situation is, as the order states, withheld until the threshold is reached for reimbursement of costs.
Okay, so under that scenario, will Pocahontas Gas ever be making, let's assume that enough production is realized to reach that threshold. Will there come a point in time then when Pocahontas Gas makes a direct payment of a 1/8 interest royalty or some other amount directly to lessor Buchanan Energy?
Pocahontas Gas would pay the entire working interest to Diversified, and Diversified would then pay the share of Buchanan's royalty from that working interest.
Okay, what if, okay, so let's address the other scenario. If we're assuming that you prevail here, obviously, but if you do, and Diversified elects to participate as a participating operator, which is to say they're going to front the pro rata share of expenses and costs, and they're going to be fully participating. There's no need to do the 200% recovery. In that scenario, will Pocahontas Gas ever make a direct payment of any amount of money to the lessor Buchanan Energy?
The royalty would all be paid to Diversified.
Okay, so when we were here back in September, I recall your testimony being different, and that was I remember you telling me that there would be a direct payment of a 1/8 interest royalty directly to Buchanan Energy. Do you remember testifying to that?
Well, if they,
I-
excuse me, if they participate,
Well,
excuse me, no, if they
I'm asking
elect,
the witness the question.
no,
Wait, let's let her try to answer the question, Mr. Schwartz, and you can readdress it after that.
okay.
Can you ask?
Do you remember what you testified to? Because I certainly don't, so.
No, I don't recall specifically.
There was, do you remember some discussion about post-production costs and expenses being charged against the lessor Buchanan Energy? You recall that testimony?
Yes,
Okay.
in general,
Uh,
yes.
So what do you remember about that? Because that's what I'm confused about. My recollection is there was a contemplation from Pocahontas Gas that what you refer to as post-production costs would be charged against the lessor Buchanan Energy's 1/8 interest share that you were going to pay directly. And if that's not the way it works, maybe I'm confused, but I just want to get clarity on that.
That would be if Diversified did not participate, then that would be how the royalty would be paid based on the terms of the pooling order.
Okay, so that would be scenario number 3, I guess, and that is Diversified doesn't elect to be a participating operator. It does not elect to be a carried operator. It simply says we'll be, I guess, deemed lease, right? That's the
Yes,
third
sir.
scenario. Okay.
Yes.
And in that scenario, then what payment, if any, would you Pocahontas Gas be making directly to lessor Buchanan Energy?
It would be the 1/8 royalty that's provided for in the pooling order.
Okay, and in that event, Pocahontas Gas would then be deducting from that 1/8 interest royalty what you refer to as post-production expenses. Is that correct?
Yes, as provided for in the pooling order, yes.
Okay, and are you aware of any statutory authority or rule or regulation authority that would permit Pocahontas Gas to make that post-production expense deduction from the 1/8 interest royalty that you would be paying to Buchanan Energy? Can you cite me any authority that would support or authorize you to do that?
I'm going to object to that. I mean, it's in the board order, which is entered pursuant to the Virginia Gas and Oil Act, which requires the board to provide for the payment of royalty. I mean,
That's not a valid objection.
what do
I'm
you mean
asking
it's not? You're going off
It's
and
not hearsay.
pretending that that's not the
Not
law.
leading. That's not a recognized legal objection. That's just your answer. I'm
My
asking
objection
her,
is, everybody in this room knows that the board is authorized to order the payment of royalty and address deductions, and it has always done that, and it does that in the orders that are presented to it.
okay, well,
we're going back and forth here for, so your objection, I'm not sure I understand your objection. Your objection,
I don't understand it either.
I understand, you've answered this question, I believe, so I don't know why you need to object. I think, do we agree that if you're carried or you're participating, it's a direct payment to whoever to Diversified in this case? And then Diversified is required to pay Buchanan Energy from their proceeds. The third option, we have the three options. There's no other options, correct? What do you not have clarity on at this point?
I'm asking Ms. Berry as to the third option, which in my order anyway, the third option, which is deemed lease. It's Pocahontas Gas is going to, they have apparently submitted an order in this case where the board would be ordering them or allowing them to make these post.
So her answer was, it's going to be the terms of the order which this board would issue, and that's correct.
My
That is the
question is,
answer.
where does that,
It comes from this order.
other than the order though, what Mr. Schwartz told us a minute ago that she's been doing this forever. She's got all this expertise. She understands legal stuff. You allowed her to answer a legal question. I'm asking her now, what's the legal source of authority for that mechanism, if she knows?
Do you want her to cite a quotation from the Oil and Gas Act or the board regulations?
If she can, I mean, there is a requirement that the
Do you
application,
need a minute to look those up? Because, Ms. Berry?
Yes, just a moment, please. So 1620 C prescribes the requirements of every pooling order entered by the board.
Okay, thank you. Does that answer your question? She's answered your question. Let's move on.
which of, so C has 1, 2, 3, 4, 5, 6, 7 subsections. Is there a particular one that Pocahontas Gas contends authorizes the board to allow Pocahontas Gas to apply post-production expenses to deduct the one as a deduction from the 1/8 interest? Is that in here somewhere in 45.21620C?
I believe that's a different citation that we need to go to for the post-production costs allowable charges
Than what she gave me, or did I misquote it?
that she gave you. There's another one. I don't know if she's still trying to find that one or. Ms. Cooper, do you have it in front of you? What we're discussing here today, or?
I'm also currently looking, Chairman.
She's currently.
What she's.
She's currently looking also. If anybody in the staff wants to chime in that may have more familiarity with the actual regulation statutes, they may chime in also.
1620E states that any person who does not make an election under the pooling order shall be deemed to have leased his gas or oil interest to the gas or oil well operator as the pooling order provides. Thus, the terms of the pooling order as approved by the board would determine the payment of royalty.
Ms. Berry, have you submitted an order, a proposed order to the board that asks them to impose upon lessor Buchanan Energy costs and expenses that they're not otherwise required to pay under their lease?
Their lease does not require the payment of post-production costs, and the order that we have proposed does deduct post-production costs.
Are you familiar with the regulation for VAC 25-160-100?
Off the top of my head, no, but I can certainly look it up.
Read that to us.
If you can give those.
It's a little bit long, but I'll read you the pertinent parts. The title of that regulation is allowable cost, which may be shared in gas or oil operations. Subsection A says the unit operator of a pooled unit may share all reasonable costs of operating the unit.
Well, I'm going to object to that because this section applies to participating and non-participating operators, not owners, not royalty owners. It says so right in the beginning. This has nothing to do with what you pay royalty owners.
I agree. I agree with that. But I'm still going to ask her about it.
Well, then I object. It's not relevant.
Ms. Berry?
Do you want us to rule on the objection before you proceed?
I'm sorry. Maybe not.
Do you want to chime in on any relevance?
Yeah, we're talking about three different scenarios overall here. So this, according to Mr. Schwartz, this would apply to the first two. So it seems like it's within the framework of what we've been talking about.
It doesn't apply to royalty. You're asking about royalty. And this statute has nothing to do with royalty owners. It has to do with people who participate as joint operators in a unit and how they share and allocate costs. It has nothing to do with the payment of royalty to a royalty owner.
So it would apply to my client, right? If we elect to participate.
Correct.
Okay, can I ask about that?
Go for it. I mean, but it's not in our order. I mean, it's a rule. It's a board rule.
What's your
What are you going to
question?
ask me?
I
just makes no sense.
have you located the regulation?
Yes, sir.
Okay. And that is a regulation that applies to participating or non-participating operators, correct?
It is.
And when the phrase non-participating operators, that's another way of saying a carried operator, right? Just in terms of terminology.
No, a non-participating operator would be if you elect under 9.3 as a carried interest, you are a participating operator, the means by which the costs are recovered differs.
So there's a definition in the statute in the Virginia Gas and Oil Act, and it defines a non-participating operator. This is 46.2/1600. It says a non-participating operator means a gas or oil owner of a tract that is included in the drilling unit who elects to share in the operation of the well on a carried basis.
Okay,
Okay. So for purposes of this unit that you're trying to pull as regards, insofar as it pertains to my client Diversified, if Diversified elects to be a participating operator, which in other words, they would fund their share of the appropriate costs on the front end or be a carried operator, then Pocahontas Gas would be limited by this regulation to only pass along the reasonable cost of operating the unit. Is that your understanding under this reg?
under that regulation, it lists drilling and production operations. Under number 2A.
Well, there are also direct costs. Well, right, there's a
True.
category,
Yes,
direct costs and then indirect
yes,
costs.
direct costs and indirect costs, yes.
But all of those are subsumed within the subsection A, which says cost of operating the unit, right? See that in A?
Yes,
Okay. And the cost of operating the unit, those would not include post-production, post-operating expenses, would they?
I don't think that's an area that I can speak to.
Okay. All right, so let's move along then. Ms. Berry.
Yes, sir.
This is a pre-mark exhibit number 2. I'm gonna pass this out to the board. And if Ms. Berry, you can look at, and feel free to pull up the plat that you were looking at too. It doesn't vary from this, but just easier for me to see. With respect to the plat of the mine works,
Okay,
you have that? Let me focus your attention on panel 20, for example. Panel, not for example, but let me focus your attention on panel 20.
yes,
And you agree that there are 7 80-acre units that encompass all panel 20?
the entirety of proposed panel 20 is not depicted on this map, so I can't tell you that from this particular map.
Okay,
Because we've only addressed panel 19 in our application.
in response to Mr. Schwartz's questions, I thought I heard you testify that you own 100, you have voluntarily pooled units E39.
E39 and E40, yes, sir.
40, yeah. And so in addition to those 2 units, according to Exhibit 2 that I'm looking at, there are 1, 2, 3, 4, 5 other units that stretch to the west of those 2 units. You're aware of that?
Yes,
Okay. And so if we include the 5 that stretch to the west and the 2 that you mentioned before, let's talk about those 7 for just a minute, okay? The first of those, starting with the westernmost unit,
I don't see anything currently playing that I can resume. What would you like me to do instead?
AI is taking over the questioning. this is not on your plat, but it's on Exhibit 2. And it shows the westernmost unit as E34. Are you aware of that? You're aware of E34?
Yes, sir.
And in the same respect that your company controls all of E39 and E40 through a lease of 100% of the interests, would you agree that Diversified controls 100% of the interests in E34 through the same mechanism, which is to say a lease?
Yes,
And insofar as it's your position that Pocahontas Gas has voluntarily pooled E39 and E40, you would agree then that Diversified has, in the same vein, voluntarily pooled E34, right?
yes, sir.
And same question with regard to E35. Diversified has voluntarily pooled that as well.
Yes, sir.
And the same question with regard to E36. Is that true?
Yes, sir.
Okay, so of the 7 units that we're talking about in panel 20, Diversified has voluntarily pulled 3 of those. Is that right?
Yes,
And E36 was on the agenda today, but you've withdrawn that petition, that application to pull. You really don't need to pull that, do you, to proceed with your panel 19 production? And isn't that why that you have, in part at least, you have withdrawn that application? You don't need to pull E36 to produce the gob wells in panel 19. Isn't that correct?
the Oakwood 2 rules require us to allocate production to that acreage.
Well, that may be so, but that's not my question. My question is, Pocahontas Gas doesn't need to pull E36. That's right. Isn't that why you've withdrawn the application for E36? You don't need to pull that to do what you want to do on panel 19. Isn't that correct? And if you don't mind, would you focus your attention on us for just a minute while you're answering? You
I'm
understand?
sorry.
You understand the question?
I guess my
Yes.
objection to that is we all have papers on our desks that we're looking at. And are you telling her she can't refer to her documents, applications, exhibits? I mean, what do you mean she can't look at her desk?
I didn't say she couldn't look at her desk.
Well, you did. You said you wanted her to look directly ahead. I mean, that's what I understood. I mean, what is this?
Let's move on from this. You want to restate your question?
Right. The reason that you've withdrawn E36 application is you don't need to pull any part of E36 to operate gob wells that are in panel 19. Isn't that correct? You don't need to pull E36. That's right, isn't it?
We aren't proposing a gob well in the acreage of the 1.05 acres that E36 bears to the 19 panel unit.
Right. And that's why you don't need to pull E36, correct?
We're not pulling it at this time.
Okay. And do you have any present intention to try to come back and pull it, in the near future?
Not that I'm aware of.
In other words, you're going to continue with your gob well development in panel 19. You'll produce gas from those gob wells, and then you're going to render a payment that corresponds to the allocation for that little 1 acre square. And you're going to do all of that without pooling E36, correct?
Yes,
That's because you and no one else is going to put a well in that 1 acre tract in E36, right?
correct.
So on the unit we're talking about right now, E38, there's also, whereas on E36, there was a 1 point, I guess what did we say, 1.05 acre, something like that? Let's
Yes.
just call it a 1 acre just for simplicity. On E38, there's also a section, it's not 1 acre, right? But it's a section of property that's within E38 that actually overlies the proposed longwall panel, which is panel 19, right?
Yes.
And no one proposes a well there either. That's what you testified a moment ago in response to Mr. Schwartz's question, right? There's not going to be any gob wells in that piece of property either, is there?
No.
Okay. So if you don't need to pull E36 because there's no gob wells that are gonna be in the 1 acre portion, and you're not gonna have any gob wells in the portion that we're talking about in E38. Therefore, you don't need to pull 38 either. Isn't that correct?
There are more than one tract involved within this unit, as opposed to E36, which is one piece of property.
But that's not the litmus test that you just explained to the board. You said the reason that you don't have to pull E36 is because there's not going to be a well in that 1 acre. That's the litmus test that you explained. So if there's not going to be a gob well in the southern sliver on E38, the same thing is true regardless of who owns it. You will still be able to operate your wells in panel 19. You said that you have production there for these little parcels, and you'll render a payment to the owners of the parcels. That's the same situation you have in E36, right?
Essentially.
Which means you don't really need to pull E38 today, do you?
I think that's a question for the board.
Okay. So if you were successful in pulling E38 today, the order that you proposed to the board would pull all production interest in E38, not just the little purple section. I may be getting the color wrong. My wife would say it's probably magenta or something. She's an art teacher, but you're not pulling just the little southern border of E38. You're pulling the entire 80 acres in E38, correct?
Right, because we're required to allocate the entire ownership of the unit to the panel. And there's more than one owner.
And if the board were to enter that order, that would place you in control of E38 until someone comes along and tries to change the order, right? This would apply, for example, 3 to 5 years down the road when panel 20 comes into production, wouldn't it?
If there's no production that occurs within panel 20 within 2 years, we would have to come back before the board.
Well, that's not true if there's production out of panel 19 though, because then you would be able to say that unit E38 has seen production within 2 years. So that order wouldn't go away as long as panel 19 is producing, would it?
We still have to bring before the board the percentages and allocations for the new proposed production.
But that would all that would require is you to amend the pooling order to include the new percentages based on wells that may be proposed in panel 20, right?
Yes.
You wouldn't have to go back and cancel out this order and get a new order. You would just amend the one you've got, right?
That's correct.
And is that when you use the word repool, is that what you mean by that?
Yes.
You and I were talking a few minutes ago about Virginia Code Section 45.2 1620 And you pointed out subsection C,
Yes,
right? And you
Yes.
said in there, what you said was that sets forth the things that have to be included in an pooling application, as I recall.
in a pooling order.
Okay, and so subsection C1 then says, the pooling order shall authorize the drilling and operation of a well. That's the very first requirement for a pooling order.
I'm sorry, I'm going back to that section. Can you restate your question again, please?
Yes, ma'am. I'm referring to Virginia Code Section 45.2, 1620, Section C, subsection 1. And it says every pooling order entered by the board pursuant to the provisions of this section shall, number 1, authorize the drilling and operation of a well. See that?
Yes,
The order that you have proposed to the board, does it authorize the drilling of and operation of any well in E38?
no,
Have you done a calculation as to what percentage of panel 20 Pocahontas Gas leases? Or
no,
otherwise controls?
no.
You testified on direct examination that Pocahontas Gas projects the need to drill, or I guess projects that panel 19 will be produced through approximately 14 gob wells. Is that correct?
Yes,
And you said the average projected cost of each one of those is going to be a little over $750,000.
yes, sir.
And you know, at this point, I'm sure from the prior hearings, that those well costs are going to be reimbursed to you or to your company from Coronado. Is that
I'm
correct?
object to the relevancy of that issue. We've been round and round on that.
Those are different cases. We have to establish a record on.
Okay, well, we have an objection from Mr. Schwartz to the question regarding reimbursement of cost. Do you want to address anything else before we further discussion? His objection? You're saying it is relevant, is what?
I don't want to spend more time than I need to, but there's a lot to say about that. So would you like me to?
No.
Like, I withdraw that question. Yeah. Yeah, part of what is part of what the board has to do here and what the application has done is to project reasonable costs. And of course, it's our position that those costs have to be based in reality. They have to be real. They can't be these, they can't be a cost, which is sort of like what someone else might charge in a similar situation. We're talking about a particular panel, particular wells, particular costs. And it's our position that if Coronado is reimbursing Pocahontas Gas for $750,000 for every well, so that Pocahontas Gas doesn't have any money out of pocket, and Pocahontas Gas is getting $750,000 for every well from Coronado, And then Pocahontas Gas is turning around and requiring participating operators to also pay $750,000 to Pocahontas Gas. Pocahontas Gas is getting two payments of $750,000.
I think we understand that,
Okay.
that part of we've heard all these arguments before. You've objected to the relevance of the question. You got anything else to add, Mr. Schwartz? I think we've addressed this.
I think our private agreements, when we sold the coal, are not fair game. They're not relevant to our application.
Thank you. The board have any other questions concerning the objection on the relevance of the reimbursement drilling costs? We need to have any further discussion. Do you have a motion to uphold the objection or to abstain the objection?
Make a motion to uphold.
We have a motion to uphold. Do you have a second? I'll second that motion. All those in favor of sustaining the objection, say aye. Aye. Those opposed?
Aye.
Say,
Okay, the objections are held. We can move forward. The questions are relevant.
I need to add something to that, just for the record.
Let's ask questions. That's what you're doing. You're addressing the witness, not the board.
For the record, I need to proffer a couple of things just so we get the record straight.
This,
But
you can do that through your witness examination. Can you?
no, the proffer is something different. This is more of a legal question. If you want to ask Ms. Cooper, I probably not up to me to explain that to you.
Can you give us some guidance there, Ms. Cooper?
Yes, he can briefly proffer something to put on the record, but there should be no decisions on it or anything else made after that.
Okay.
It's purely
You
for
may go
purposes
ahead.
of appeal.
Thank you, Stephen.
Couple things. One is we had hearings in other cases that started in 2025, and this issue of cost reimbursement did come up. But the board did not rule that those were irrelevant. That's not what the board. In fact, the board's attorney said that they might be relevant in those questions. So to the extent that the board thinks it's adopting a prior ruling that this was irrelevant, that's not actually the case. Because we did hear lots of testimony about this case, and it is relevant. Is that in fact, there's almost nothing more relevant than what are the actual costs going to be in this unit, and how could there be anything more relevant than that? But for the record, I'll proffer that Pocahontas Gas, through its affiliate CNX, has filed documentation with the SEC where it has, to the federal government, where it has stated that it does not have any capital costs with respect to any of these wells, that all of these wells are quote funded by Coronado, which means all of these wells, including the plugging costs, are paid for by Coronado, not Pocahontas Gas. And so I'll proffer Exhibit 8. I moved to introduce it, but so I know Mr. Schwartz is going to object, and I sense what it's going to be, but I'll proffer Exhibit 8, which is that SEC filing. I'll hand this to the clerk.
I can't really object to a proffer. You can put in wherever you want. My objection's already been sustained.
I'll move it into evidence, Mr. Schwartz, and
Well, it's not going to be received in evidence because proffers aren't received in evidence. It's a proffer.
I said I am moving it into evidence.
Well, it can't be. It's been rejected as irrelevant. It's part of a proffer. It's not evidence.
It would be moved into the record, Mr. Chairman,
It's in the record.
but not considered as evidence in the current petition. That's how that would work.
It's in the record.
Ms. Berry, you stated earlier that you're familiar with the way the Oakwood 2 rules work, right?
Yes, sir.
And you've probably been dealing with those for quite a while, I assume.
Yes, sir.
You do understand that Oakwood 2, the Oakwood 2 rule as amended, serves to allocate production to the different interest holders within a drilling unit, right?
Within the panel also, yes.
Yeah, well, if you have a panel, it may extend to other units, but it's a mechanism to allocate production, right?
Yes, sir.
And so if and when, should you prevail in this case, and Diversified has the right to make an election to participate or to be carried, and they make that election, they would then have a certain volume of gas allocated, the production of that gas allocated to them on a periodic basis, for example, monthly. Isn't that correct?
Yes, sir.
Now, do you know whether Pocahontas Gas or any of its affiliates intends to utilize gas that is production that's allocated to Diversified, if and when that happens? You know, if Pocahontas Gas intends to utilize or generate environmental revenue credits for gas production that's allocated to a party like Diversified that has an election?
I'm going to object to the relevancy of this question. We've gone round and round on alternative credits, carbon credits. They're not relevant. The board's decision that it entered based on I think in October, that addressed energy credits as not relevant to a pooling application, just as it addressed the well reimbursement cost as not relevant. So I think we've got a decision. I'm objecting to the relevance of this.
Mr. Street, if you wanted to rephrase that question to where it states that, does this application include anything to address that? You may do it that way, but this application does not, in its current form, does not have anything in it that indicates any opportunity to sell this gas for generation of carbon credits. So it's not relevant from that standpoint. If you're talking about another application or something else, fine, but this application, it's not in this application. So it is not relevant.
Why don't we do this if this is you, and the board? I anticipated Mark or Mr. Schwartz would object, and I think for the purpose of the record, if you're going to rule against me, go ahead and let's get that on the record. I hope you won't, but if you do, let's do that, and then I'll try to follow up with a different question that maybe gets to what.
Because an objection by Mr. Schwartz is regarding the application. Does the application contain anything that related to carbon credits? Do you have a motion that the objection is upheld or overruled?
Make a motion that it's upheld.
We have a second.
Yes, sir.
We have a motion and a second. All those in favor say aye. 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 Any opposed?
Abstain.
Move on to your next.
Okay, so Ms. Berry, has Pocahontas Gas ever filed an application that asked the board to allow it to generate environmental credit revenue?
Same objection. This application.
It has some relevance to this application.
Okay, well, sure. Ms. Berry, does the application and the proposed order that you've submitted in E38 mention environmental credit revenue?
No, sir.
Does it ask the board in any way to sanction or approve of your company's generation of environmental credit revenue on gas production that's allocated to Diversified?
No, sir.
If you intended to do that, if your company right now intends to generate environmental credit revenue based on gas production that is attributable to Diversified, would you include that in your application? Would you think that it's appropriate to go ahead and put that in application and include that in a proposed order so that the board can make a decision about that aspect of your revenue base, just like it has for other applicants to generate environmental credit revenue? Would you do that?
Yes.
Okay. So the fact that you haven't done it in this case tells me that Pocahontas Gas will not be generating any environmental credit revenue on gas production from E38 allocable to Diversified. Is that a true statement?
I don't think I can speak to that.
So you don't know, sitting here today, one way or the other, whether your company intends to generate that revenue?
I'm going to object to this again. I mean, our application is to produce gas and sell it and pay a royalty on the proceeds that we receive when we sell it. We have been over and over and over this in September. We're not, that's what our application says that's what we intend to do and how we intend to pay if it's approved.
So if Mr. Street wants to rephrase this question to state that if any gas from this application, associated with this application was going to be used for generating carbon credit, they would have to come back in front of the board and get approval. That's a fair question, correct?
Okay, I'll adopt that question, Ms. Berry.
Yes. Yes.
I don't have any questions.
Okay. Do you have any questions from the board of Ms. Berry?
Mr. Chairman, if there are no board questions.
Yeah, go ahead. You can have your chance to respond to those questions. The board will wait till then.
I just want to ask Ms. Berry, if you were asked a series of questions about the idea that we didn't have to force pool. Let me get the map back up here. Can you show us the map again with the
Sure.
pink? Okay.
Sure.
All right, you were asked a series of questions about the I guess it's a pink area in E38 that we're now talking about. And that ultimately the question was, so you don't really have to pool E38, you can just pay royalty on the pink area in E38 to Buchanan. Do you recall those questions?
Yes.
Okay. If you pool this unit, Diversified E38, Diversified has an opportunity to elect to participate or be carried with regard to the pink acreage, correct?
Yes.
If you adopt Mr. Street's idea that you don't need to do this, Diversified would have no opportunity to participate, correct?
Correct.
And Buchanan would not be able to look at Diversified and say, participate, honor your lease, correct?
That's correct.
I think that's all I have on redirect to move this along.
Ms. Berry, that is true on E36 as well, isn't it? The application that you just withdrew this morning, right?
Right.
So unless Mr. Pruitt has something, I didn't cut him out.
No questions.
Now we'll take questions from the board for the witness. just to clarify, Ms. Berry, one last time. Is there a reason that Pocahontas elected not to move forward with including panel 20 as part of this pooling application?
Because we don't have enough information at this point in time from Coronado to proceed with calculating the interests and as far as the timing of their plan of mining.
So I'll refer you to, we've got other docket items today where we have the competing applications on E37 and that one, Diversified in their application does include the panel 20.
They
However,
do.
Pocahontas does not. So the information must be available from Coronado at this point in time to be able to do the entire unit if you so chose. Is that not true?
That's true.
So you could have included it, you chose not to.
Yes, that's true.
So is there a reason you chose not to?
I believe it's related to more of the timing issues and that's information that I believe that Mr. Ball can testify to.
Okay, we'll revisit that there then. And then also the map that you pulled up with the pink area on it, and you don't need to pull it back up, but that entire pink area is not Buchanan Energy, correct? There's other
No,
ownerships
it's-
inside that pink area. It's just not all Buchanan Energy property, correct?
Right.
I just want to clarify that.
Yes, that just reflects the portion of those ERO units that also require allocation of production from the other remaining units in the 19 East panel.
And the last thing, just for discussion purposes, we touched on this briefly in either some of the motions or maybe in the last hearing on other units, onto the methodology that was come up with Oakwood 2. And again, nobody on this board was around in 1990. Mr. Schwartz, you were probably the only person around, and you couldn't remember completely the reasoning behind why it was the methodology chosen was to utilize the 80-acre units and tie those to the long wall panels to do the pooling when it became necessary. I don't think there's probably anything to add to that at this point in time. You haven't had any revelations on any of that, or?
Well, I have thought about it, and one of the things I thought about, and I don't think I shared it with you when I addressed that issue. I think part of the problem way back when was title. And, everybody was doing title on 80-acre units. And all of a sudden, it occurred to people that if we could recycle the title that we had on the 80-acre units and apply it to these unsealed GOB units, it would be cost effective for the operators. I think that was part of it. Okay. But, and I also addressed the fact that the board had experimented with long wall panel units. And that was when we were doing frac wells. And the problem with that was that the frac well, elliptical design of the frac well would extend beyond the long wall panels. And so the board was not ultimately enthusiastic about doing that. So I think there were, alternatives that the board considered, and they all had their own problems. And I think that the choice here was it's going to be a temporary dimension while the panel is being mined and before the mine is sealed. And let's just go with that. Use the existing title in the 80-acre units and do it that way. I mean, I think the board could have decided in Oakwood to create units out of panels, but it chose not to.
Right. It's fair to say that if we were considering an entire longwall panel as a unit today, that it might be a little cleaner in this situation as opposed to having to deal with the 8-acre units on an individual basis.
I absolutely agree with that, but that's not what I have to work with when I file my applications.
Understand. So
and-
so is your opinion that the Oakwood 2 units, they rule the field with regard to longwall panel mining? That an operator, that you could have come in, could you have come in and just proposed a single longwall unit as opposed to that and done it under the field-wide rules as a unit? Or do you think that we have to go by the Oakwood 2 rules?
Well, the problem is you would have to enter an order that says we are modifying the Oakwood 2 rules to carve this piece out of the application of those rules and create a unit. I mean, you would have to do that because the Oakwood 2 rules, apply to a couple 100,000 acres.
Correct. I agree with that.
And so if you wanted to, let's just put the map back up, Kelly, okay? Let's just stay with your idea here. So if looking at 19 East, okay, if we were, we could say that we're petitioning the board to modify the Oakwood 2 rules to carve out the acreage encompassed within the 19 East panel that is currently unsealed, and we're going to create a unit out of that. I mean, you could do that. A problem with that is the safety regulations require now, because these panels are so wide, once the mining is complete in the 19 panel, it's going to be a sealed panel. So the boundaries of that sealed panel are going to be different because they're going to follow where the seals are applied, and we don't know yet exactly where those seals are going to be. So in the future, we're going to have to come back and do a sealed gob unit for 19 East that will not have exactly the same acreage and will not be either under Oakwood 1 or Oakwood 2, because neither Oakwood 1 nor Oakwood 2 apply to sealed gobs. I hope that has been helpful.
Yeah, that has. I understand that concept, and that the dealing with the sealed panels historically, before you had these wider panels, you may encompass multiple longwall panels into a new unit.
Right.
Which was, again, the same concept as just arbitrary. It's not arbitrary, but you're generating a new completely sized unit that does not take into account the 8-acre spacing units that were originally part of Oakwood 1.
Correct.
Okay. So final question is when these Oakwood 2 rules were formulated, it doesn't appear to me that it contemplated a situation where you would have 2 competing operators within a longwall panel.
I would say that was a fair assumption because nobody was doing this except, well, at the time Oakwood 2 was initiated, Oxy USA and Island Creek were doing this, and Pocahontas Gas Partnership and Consol were doing this.
Correct.
And basically they drew a line kind of down the middle of the Oakwood field, north to south, and their lease holdings kind of contributed to that. I mean, they actually had pretty much the beginning of a line from north to south. And one company, coal company and oil and gas company, said, we're gonna develop this stuff on the east, and you're gonna develop it on the west. And then we did some things to square up that line, but the assumption was it was either going to be Pocahontas Gas Partnership and Consol, or Oxy USA and Island Creek at that point, and that you wouldn't have somebody else in a panel unit.
Okay, thank you for that. You may call your next witness.
Okay, I realized I wanted to cover one more thing with Kelly. Well, I think I did cover that. Never mind. My next witness would be Josh Ball. Josh, you on?
Yes. Yes, I'm here,
Okay.
Bob.
All right, great. I'm going to remind you, you're still under oath, okay?
Mr. Chairman. I think we could take a 5-minute break before we just let us get. Take a rest.
We're only 15 minutes from probably the lunch break, so I was gonna try to get through.
Okay.
I don't think.
I thought there might be other people that would appreciate it. Break, but I can make it.
Go ahead there, Mr. Swartz.
Okay, Josh, who do you work for?
CNX Resources.
And
Pocahontas
how
Gas.
long have you been with them?
A little over 18 years.
Okay, what is your current position or title?
Director of Drilling and Completions.
Okay, and in that capacity, are you responsible for drilling and completion of gob gas wells?
Yes, I am.
Okay, and did we ask you to do an estimate of what the average gob gas well in panel 19 with a reasonable average cost of a gob gas well in panel 19 would be?
Yes.
And did you provide us with that number?
Yes, I did.
Okay, and for the board's look here. I believe your estimate is at page, let's see here, page 13 of the PDF. And what is your estimate of the average cost of a well in that panel?
Let's see. Grand total well cost, I have 753, 344.
Okay. And how did you come up with that estimate?
It's compiled from a multitude of data sets in the area, revised as additional drilling and cost data is generated, and it's updated every so often.
And that data, is that actual well costs that you've experienced in the area?
Yes, it is.
And that's the source of, or the data on which you relied to come up with this opinion?
That is correct.
Okay. And is this a reasonable estimate of the cost of a well to produce gob gas essentially above the Pocahontas 3 seam?
Yes.
Okay. And your estimated depth is what?
I was trying to look. I think it's estimated there at 1,829 feet.
That's what I'm looking at as well. Okay. Have you had, can you tell me what input, if any, Coronado has into your planning for drilling, locating wells and number of wells?
Yeah, so Coronado will essentially give us a panel design. There are certain baselines on the panel where they desire the bottom location of a well to be placed. We evaluate the topography and the surface in that area and try to get the wells as close as we can to be able to meet the bottom hole requirement.
Kelly, could you put that map that we keep wearing you out back up? Josh, can you see that?
Yes.
Do you have well locations from Coronado with regard to the 19 East panel?
I do have a plan that we developed. I don't have it in front of me right now.
Right, no, I don't need you to show it. Do you have a plan that you've developed with Coronado for 19 East?
Yes, we do.
Okay. And is it, and does that plan include well locations in areas that Coronado would like to see them located?
Yes, it does.
Are any of those well locations in the plan in the pink area?
Not that I'm aware of.
Okay. Are any of the well locations in the plan in E36 or F36?
Not that I'm aware of.
Okay, okay. With regard to the 20 East panel, okay? Let me see if we've got a better, well, actually this map will work. The 20 East panel would be immediately above the coal barrier between 19 and 20, right?
Yes.
Okay. What is the status? Strike that. Before I go to that, have you had discussions with regard to with Coronado with regard to the timing of mining in the 19 East and 20 East panels?
Yes, I have.
Okay, what is Coronado's start date for 19 East?
The most recent projection that I have for 19 is to start on October 12th, 2027 and to complete on June 23rd, 2028.
Okay. Do you have any information from Coronado with regard to a start date, end date concerning 20 East?
I do. So the current information I have on 20 East is set to start March 29th, 2029 and finish April 21st, 2030 with a caveat that there's a potential delay plan in place to mine in a different area prior to going to 20.
Okay. Let me see if I can. There is what would delay that? What is Coronado telling you might delay the start of 20?
The main development is behind approximately 9 months for the time. And if that main development was not caught up and on schedule, they would not be able to start the longwall panel.
By main development, if we're referring to the map you have, we all have in front of us, if we look at the left-hand side of that map, there's some pretty significant entries with blocks of coal on the left. Is that a main?
Yes, where the cursor is. Yes.
Okay, and the that main is going to turn and go to the west off of our map, right?
Correct. Yes.
And is that the main that is behind schedule?
Yes, it is.
Okay, and that main would need to be completed before the 20 East panel could be developed.
That's correct.
Okay. And what is the proposal or what is the concept that Coronado has to do in the meantime, given the delay?
The proposal that was discussed was to move the longwall
Mr.
upon
Chairman,
the completion of.
I don't know what the testimony is going to be, so it makes it hard for me to know whether I should object or not, which means I have to object to the hearsay.
Okay, I'll withdraw that question and ask a different one. What is your understanding of where Coronado is going to be mining during the 9-month delay?
Same objection, unless they can establish a predicate for his testimony. It's something other than hearsay.
Do you have someone, Coronado, who can address this issue for you, Mr. Schwartz, or do you want to move on?
Mr. Ball, have you seen maps with regard to the proposed mining that's going to occur in this 9-month delay that we're talking about?
Yes, I have.
Okay, and where do those maps show the mining is going to occur?
1 and 2 west.
Okay, and Kelly, do you have, I'm gonna try to share this again, but I'm not having any luck with that. Let me see here. Yes. Can everybody see that?
Yes.
Okay, can you see it, Josh?
Yes, I can.
Okay. Is this a map that you provided to me?
I believe it is.
Okay, let's go up to, sort of toward the top of this where you've got 19 East Longwall or LW. Do you see that?
Mm-hmm. Yeah.
And you've got a circle around the mains,
Yes.
and that's roughly where we are now, or they are now.
Right.
And then you've got a circle off to the left.
Mhm.
What does that mean, that circle?
It represents a deficit in time. So the right circle is actual location. The left circle is where they should be based on current mining projection and timing.
Okay, so that's the 9 months that it's gonna take them to get from where they are now to where they should be.
That's correct.
Okay, then down at the bottom of this, or toward the bottom of this mine, we show, we follow the main down to the south and we show all the areas that the longwall panels that have been mined. But then we've got something at the bottom, 2 short panels, west 2 longwall and west 1 longwall. What's that?
Those are the 2 panels that I was told by Coronado that they would move to after 19 to get to bridge the 9-month deficit in time.
Move to strike.
Mr. Schwartz, we have an objection to the hearsay of Coronado.
Well,
Did you hear the objection?
Okay, I guess
I guess
I'll
could you
just
maybe
ask.
try to tie the relevance of the delay in mining to this pooling application?
Okay, well, I'm just trying to, yes. Do we know, I'm gonna withdraw that question. Let me ask this question. At the present time, do we have a map of the 20 East Longwall that is sufficiently detailed for Kelly and the people that she uses to map, Patrick, to calculate acreages so that we can calculate division of interest for 20 East?
I don't know that I can answer that accurately.
Okay, well, look at 20 East on the map that we're looking at right now. Do you see it at the
Okay.
top?
Yes.
Would you agree with me that no one could use that projection to accurately calculate the division of interest of owners in that panel?
Objection asked and answered, objection leading. Witness testified he didn't think he could answer that.
It's a different question. Yeah, my question is, based on the 20 East mapping that you see in front of you right now, can you tell me whether or not it is sufficiently detailed to allow the calculation of acreage to permit a computation of division of interest of the owners in that panel?
Objection has been answered.
Say that it
He's still
is.
objecting, Mr. Forrest, before you answer.
It's been answered.
I'm not sure what the relevance is to this application.
Okay, the relevancy is there's a complaint, apparently, that we haven't included 20 East. Kelly testified she hasn't included 20 East because she doesn't have mapping that would allow her to do the calculations, and I'm simply asking Mr.
Understand.
Ball if he has better information or if he doesn't.
Well, just from my limited knowledge of just seeing this map today, I see the outline of a long wall panel for 20. And that seems to me that's sufficient to calculate all the acreages within that long wall area as it stands today. It may change and you would have to come back and modify everything, but you have something today to go by. Is that not fair? You have a plan right there that
We have a plan, but it
may
is-
change. I understand that. but you
Okay,
could have
that's
used that
where
plan
we're
today.
going. That's where we're
You could have
going.
used that
Okay.
plan today.
We
That was my
could-
only point before.
Okay, in theory, you're right.
Okay, move on. We've addressed that.
Okay, okay. And let me just check the notes here. I think that's all I have of Mr. Ball.
Okay, that's all. I think at this point in time, we'll take our lunch break and we'll resume at 1 p.m. That's acceptable,
Okay.
everyone.
All right.
Come back with cross-examination. We'll recess until then. Okay, everyone, welcome back. We're back on record of the hearing on February 17th, Virginia Gas and Oil Board. We're on item number 4, docket number VGOB 250715-317. I believe we left off with you, Mr. Schwartz. You had finished your examination of Mr. Ball.
Yes, I think we're going to start cross.
Ready to start cross-examination, Mr. Ford.
We're ready to proceed. I don't have any cross-examination questions.
I have one question, Mr. Ball. Mr. Ball, the timing maps that you've been testifying from, don't they have a disclaimer that reads in effect that this timing is probably going to change?
I've never saw that.
On the bottom of the map, I'll read you the language I'm referring to. The mine plan, design, timing, and the property plan is forecasted several years in advance and will likely change for any reason known or unknown at the time of the map generated. Have you not seen that language on any of the maps?
No, sir, I've not paid attention to that.
Okay. Could be there and you didn't notice it?
I'm not. gonna
Asked and
say-
answered.
No, he said he hadn't paid attention to it.
Well, if he had,
Are you saying
Go
it's
ahead.
not there?
You just read it to me, so obviously it's somewhere.
All right. That's all.
Anything else, Mr. Pruitt? No. You need any redirect? Mr.
Nope.
Schwartz?
nope,
Questions of the board of Mr. Ball? I think Mr. Ball can probably answer some of these questions that I may have just to clarify some things that have been said up to this point. So make sure we're all on the same page. had a lot of back and forth, so I think some people got a little bit confused. I know we're talking about F-37 right now, I think. F-36 is what we're on right now, correct? But we had a lot of discussion on the E-36 on the 1 acre down in that area. And we've withdrawn the E-36, but it was implied that that did not need to be pooled by Pocahontas Gas, I think by Mr. Street. Now, it would need to be pooled, I believe it would need to be pooled if Pocahontas Gas is the operator of that unit before they could mine that and produce that gas off that 1 acre. Is that correct, Mr. Ball?
I couldn't answer that. I mean, that's
Okay,
not my,
we could probably go back to Miss Berry could answer that, Mr. Schwartz.
Well, is the question? I mean, I think
Who
the
the
question,
operator is of the unit, correct?
I think that I do not think. No, let me start this way. We have wells in the panel that will produce gas from E36 without being located in or on E36. That's a fact.
Correct.
So I don't think we need to be the operator to produce that gas because we're producing it from wells that aren't located within E36. Does that?
So the unit has no bearing on the longwall panel, in your opinion, then?
Well, it does because the operator in the other units is required to allocate production and royalty to that 1 acre tract by Oakwood 2 order and by the orders you guys entered a couple of months ago with regard to F-37 and F-38. So we don't have to be there to produce gas, but it's commingled, it's our other wells are producing gas that needs to be attributed to that acre.
Right.
And we need to pay those people because of the Oakwood 2 rules, which apply to us. And also then there are a couple of board orders that say we need to do that. Whether or not that unit is pooled, we need to pay those people for that acre.
And regardless of who the operator is.
Well, there's not going to be an operator there, at least for the foreseeable future,
Right.
So
But
whether or not there's an operator there, we would need to pay that because we're producing gas that's attributable to that acre.
okay.
And if there was another operator there and we're producing gas attributable to that, we would still have to pay. I mean, you can't. I hope that helps.
Okay, it did. Thank you. That's why I make sure we were clear there that everybody understood what we were talking about, that 1 acre.
Okay.
I'm not sure if Mr. Street is still clear, but
I'm clear on. I think the evidence was clear on that. I would point this out to you also, Mr. Chairman, on the E36. Well, never mind. Let's just keep it.
So the other question I had for you, Mr. Ball, and again, you may or may not be the right person to ask this question of. This board has approved in the past a couple of applications for production of mine air through vent shafts that is sold by Pocahontas to another party, which is sold for carbon credits. Is that correct?
yeah, that wouldn't necessarily fall in my area, but I'm vaguely familiar with what you're talking about.
Okay. So I think there was a comment made earlier that none of the gas that's being produced from Buchanan Energy property is being utilized for carbon credits. But that's only associated with a well. Is that correct? The mine air gas is not associated with a well because it goes under another docket item, and that gas that's being produced is being sold by Pocahontas Gas, and you should be receiving royalties on that already. Is that correct? Was that your question earlier? Did that clarify? Did that clarify that for you, though, that your question that there is no gas being produced and being sold for carbon credit? That clarifies?
We're aware of that.
Okay, you're aware of that. Okay, just want to make sure that we're on the same page there. Okay. You go to your next witness, Mr. Schwartz.
Okay, I'd like to call Greg Braden.
Yes.
You got your mic on?
Yes, sir.
Okay, great. I'm going to remind you, you're still under oath, okay?
Yep.
State your name for the record, please.
Greg Braden,
Who do you work for?
CNX Resources.
What do you do for them?
I'm Vice President of Reservoir and Asset Development.
Okay. Do you have an engineering background?
I do.
In what?
Petroleum engineering.
Okay. How long have you worked for CNX or its affiliates?
Since 2012.
Okay. Did I or Kelly ask you to do a recoverable reserve estimate for panels 18 East and 19 East?
Yes.
And what did you do to come up with those estimates?
So we have to look at the acreage that the panel is encompassing, and then take historical production and create the type curve.
Okay. And having done that, what is your estimate with regard to panel 18 East?
18 East, we have a P10 range of 13 BCF and P90 of 5 BCF.
Explain to the board what the P10 and P90 mean.
The P10 is basically, it tells you there's a 10% likelihood that it would produce 13 BCF. P90 is a 90% likelihood that it would produce 5 BCF. So 90% confidence that at least 5 BCF will be produced. And then there you work your way up to 10% confidence that 13 BCF would be produced.
So it gives you some indication of the confidence levels on the low end and the high end.
Yes, sir.
Okay. And what is your estimate for the 19 East panel?
So 19 East, we have an estimate of P10 of 12 BCF and a P90 of 5 BCF.
That's all I have, Mr. Chairman.
Questions?
No questions. No questions.
Okay. Thank you. You go to the next. Any more witnesses, Mr. Schwartz?
Yes, I'd like to call Jonathan Belcher. Jonathan, are you on? We need to be able to see you. Great. Okay. Let me see if I can get your exhibit up. Give me a moment here.
Excuse me, did we swear Mr. Belcher in?
Mr.
I
Belcher,
believe you
you
did.
swear-
Okay, I'm sorry. I just want to make sure.
Do you recall that we swore you in, Mr. Belcher?
Yes, sir.
Okay, great. Ask, can the board see this exhibit? On your screens?
I can't read it.
I'm sorry.
Is this the same one in there, the application, or is this? more
This is
information?
this is not in the application. It's an example of allocation back to panels. We've seen it before, but
If you can zoom in, that would be great. Otherwise, I think we've seen this before, so.
okay. Let me get, does that help?
Yes.
Okay. And I'm not going to spend a lot of time on this, but I feel like I need to put this evidence in, Mr. Chairman. Mr. Belcher, who do you work for?
CNX Resources,
How long have you worked for them?
since 2011.
What is your job?
I'm a lead specialist in hydrocarbon allocations.
Okay. And is that a way of saying that you're responsible in part for allocating sales back to wells?
That is correct.
Okay. And the well involves a division of interest and acreage calculation, but the first allocation that needs to occur, is that addressed by your chart that you've given us?
Yes. So the first
Oh.
level there is sales
Okay.
at the top there.
Okay. Why don't you work through this with us quickly in terms of what you're capturing and then what you're allocating and how that works?
Yeah, sure. We take total sales production and we minus third party on our system. And what's left there is that third number, total sales less third party. I allocate that back to the station level on our in our operation. And then I allocate that further to the wells behind each station group.
Okay, in this example, you have, for example, the first panel, you're in the example is 12 East panel, correct?
Yes,
And you assign, do you have a meter ID for every one of those wells?
yes,
And then you've got MCF and MMBTU numbers for each well, correct?
yes,
And then ultimately, all the way over to the right, you take the wells collectively and you give us a total for the panel, the 12 panel, which is a collection of all the production from the wells in that panel, right?
yes,
And then that number is reported to the people that are responsible for the division of interest, and they use that number to pay royalty.
that is correct.
Okay. And is this done for every panel that CNX has units that operate and produce GOB gas?
Yes, that's done for this process is done for every well on our property.
Mr. Chairman, that's all I have.
Questions from Mr. Pruitt or Mr.
I
Stern?
have no questions for you.
Are these numbers essentially wellhead production?
You've got wellhead production on here and you have allocated sold production.
Different. Could you hear me?
No, I didn't.
What's the difference in wellhead production versus allocated production? I think it's your term.
Wellhead production is what come out of is what was measured at the wellhead. And allocated production is what made it to the sales meter at the sales point.
So there would be a drop in line lossage, for example, or what are the type of things that would make the allocated production figure different from the wellhead production figure?
It could be line loss. It could, be any sort of loss or leak from wellhead to sales.
Other than losses or leaks, is there any other charges that come back in the nature of sales costs? Anything else that's allocated?
I can't speak on that. I just take what was measured at the sales point and that gets allocated back to each well based on its measured value.
So you're talking essentially about volumes.
Yes, sir.
Okay. No further questions.
Okay, can you redirect, Mr. Short?
Nope.
May call your next witness.
Just get rid of my screen here and check my notes. I believe that's all I have on direct.
Mr. Street, call your first witness.
Call, Rocky Stillwell. Please state your name
Rocky Stillwell,
and who are you employed by?
Diversified Energy.
What do you do for them?
I do permitting, environmental, EHS, work.
Let me show you what I've pre-marked as exhibit number 1. Do you recognize that to be the coal bed methane gas lease
Correct. Yep.
between Diversified Energy and Buchanan? Diversified and Buchanan Energy.
Correct.
You got the post-lunch.
Speak up, please, Mr. Street.
Okay. Want me to repeat all that, or do you think it?
Picking it up.
Okay. All right, so Jeremy, will you just hand this down to the board members? Let me also show you, Mr. Stillwell, what's been pre-marked for exhibit number 2.
Okay.
You familiar with that plat? Okay, and does it depict an acreage that is in pink or red, maybe?
Hey, yeah,
What color would you describe that as? Pink, okay. Does that pink acreage, is that a portion of the acre subject to the coal bed methane gas lease, which is exhibit 1?
correct.
We'd move exhibits 1 and, if I didn't already, 2 into evidence in this case.
So moved. We have coming.
See what.
Look at exhibit 2, Mr. Stillwell. You see panel 20,
Yes, sir.
and you see the 7 units that we have outlined in yellow.
Yes, sir.
Starting on the westernmost unit, which is probably E34. Does Diversified have a operating frac well in that unit?
Yes.
Does Diversified have an operating frac well in the next unit to the right, which is E35,
Yep.
E36,
Yes.
E37?
Yes.
So 4 operating frac wells producing in those units.
Correct.
And each one of those will be undermined by the projected longwall panel 19.
Correct.
I don't think you need it. E38 is the unit we're on here today. That does not have a well, operating well by Diversified, does it?
Correct.
And have you observed any calculations which would answer the question as to what percentage of panel 20 is depicted on exhibit 2 is owned by Buchanan Energy and leased by Diversified?
You say that again now.
Yeah, what percentage of panel 20 does Diversified have?
I'd have to look it up.
Okay, well, while you're doing that, let me, I'm gonna pass out to the board the Oakwood order, so we get them in the record. This is 12. That's all the questions I have and on this. On this unit, rather.
I have no questions, Mr. Chairman.
All your questions, Mr.
Yeah, that's all the questions I have.
Mr. Schwartz, you have any cross-examination?
Yes, how many acres, strike that. I got two exhibits from your company with regard to the acreage in, panel 20. One you filed when this case came up for hearing in, October. And then recently, you filed a new exhibit, which also estimated the acreage in panel 20. As we sit here today, what is your estimate of the acreage in panel 20 as you draw that panel?
No, what's the total? You want the total acreage in the whole panel?
Yes.
Yeah. I can't see what she's got here. Two hundred 261.7 acres.
261.7 acres for panel 20 today, right?
Correct.
Okay. Do you know that when you filed for a hearing in October, you estimated the acreage in panel 20 as 368.92 acres?
This witness may or may not know that. I'll let him answer, but that's probably,
Yeah, I'm not sure on that, on the acre there.
we have a different witness on those, Mark,
Who would know that?
Travis Cook.
Okay. Do you know that the acreage changed dramatically from October to today? Or is that something you're just not aware of at all?
I couldn't understand what he said. You speak up a little bit. My ear is bad.
Okay, so is mine. Yours may be better or worse. Are you aware of the fact, just from discussions within your company, that the acreage in, projected acreage in the 20 panel changed by, looks like, about 100 acres from October to today?
I can't remember. If I told you, I just can't remember.
Okay, so I need to talk to somebody else about why there's that 100-acre difference between October for panel 20 in your calculations and today. Not you, right?
Right.
Okay. Have you had discussions with Coronado about their mine plans? I'll strike that. Are you aware of Coronado's current thinking with regard to panel 20 mine plans?
Objection outside the scope of direct.
Well, he's telling us he can come up with an acreage for the panel today. And obviously he's basing that on some calculation of units. Why is he not capable of telling me that?
The objection is that that was not in the direct examination of the witness and it's outside the scope of direct.
Okay. Let me call him briefly as my witness then. Mr. Stillwell, do you know whether or not Coronado has plans to start the 20 panel much further, potential plans to start the 20 east panel much further to the east?
I know we met with Coronado back in Spring Diversified and my team, we met with them. They give us well locations in panel, I think 19 to the F units, and we discussed some of the 20 panel up there. We did discuss them. But as far as exact well locations, we did not start on them yet. I was actually in the field staking out wells in the F units for CNX. I mean, not for CNX, for Coronado. I was trying to save them money by picking out good well locations. So I did work with the mines and the surveyors trying to pick out the cheapest, best sites to build. So, everywhere the mines told us they wanted us to drill and not have to kick the wells, that's where we would try to save money by picking locations where they wouldn't have to spend extra. So I did meet with mines, go out in the field, find the cheapest locations I could find. Yes.
Okay, my question then is, are you aware of the fact that mining in panel 20, there is a consideration that the mining start on Consol acreage to the east?
Objection, ask for hearsay and conjecture.
You hear the objection, Mr. Schwartz?
Yeah, I'm asking him if he's aware of it. Not to guess. And Mr.
Also,
Chairman,
as to relevance,
Mr. Chairman, if I may, my caregiver is not here today, and if I could just take a 2 or 3 minute break, I'll be right back if you could accommodate me.
I'll let you for 2 or 3 minutes.
Thank you.
Okay, Mr. Schwartz, we're back on the record. You can proceed.
Thank you. I think we left off with an objection. I had asked Mr. Stillwell if he was aware of Coronado plans to move the beginning of the 20 panel to the east into Consol coal, and there was an objection. I think that's where we left off.
yeah, the objection was to relevance, what that has to do with E38, and then it would require, I think, testimony based on hearsay and conjecture.
You want to address the relevance issue, Mr. Schwartz?
Right. We're being asked why we didn't include panel 20 in our application. And the answer was a lack of certainty with regard to what that panel was going to look like. I have introduced evidence of diversified acreages that differ between October and today by 100 acres, roughly a third of the acreage in 20. The ability to actually address in a reasonable way the acreage in 20 so that we can calculate division of interest or project that is important because I'm hearing that we should have included it and we're saying we didn't because of the difficulty to know what it is. Now I've demonstrated they got a huge differential in two estimates 4 months apart. And I want to ask him why there's a difference. I want to ask him if the difference could be because of changing mine plans, because of moving the panel to the east. So that's why I'm asking about this.
It sounds like CNX is asking Diversified why CNX couldn't come up with a plan. And that's,
Yeah, I think it'll be more relevant in the future applications, Mr. Schwartz. I don't know that the relevance is important here. We understand that Pocahontas Gas will have to come back at some point in time in front of this board and repool.
Gotcha. I understand.
I think we've established that.
Okay. Mr. Stillwell, I think that's all I have at this point.
Redirect.
no, sir.
May call your next witness, Mr. Street or Mr. Pruitt, witnesses.
I don't have any more witnesses on E30.
I'll call Jason Davidson, Mr. Chairman. Mr. Davidson, have you been sworn?
Yes, sir.
What is your name?
Jason Davidson,
Who do you work for?
Buchanan Energy,
What do you do for them?
property land manager.
I've asked you this in other proceedings, but to get it on the record here, how does Buchanan Energy conduct business? What's their business plan?
We're a property holding, family-owned business that basically has a series of leases associated with mineral and or gas.
Is it your understanding that Buchanan Energy owns portion of the property under consideration in this unit 38?
Yes, sir.
Does Buchanan Energy own any surface in that area?
Yes,
How about the coal
yes,
and the methane gas
yes.
and other minerals? Is it fair to say that wherever in this area and on this unit, Buchanan Energy is shown as the surface owner, it owns these other units as well? These other, not units, but these other minerals as well, coal, gas, methane,
Yes, sir. We'd be the fee owner.
the fee owner, as it's commonly called. I'd like to direct your attention to an exhibit that has been filed with our objections. Specifically, I'd like to talk in general about the coal lease on this property. Is there an existing coal lease still in effect?
It is. Yes,
Who's the coal lease with?
Island Creek.
And does Island Creek have a sublessee?
They do.
Who is that?
Coronado.
And is the coal lease that you have just described the lease by which Coronado will proceed with mining the Buchanan Energy property in these areas?
Yes, sir.
Does the coal lease address the venting of coal, the venting of gas from the coal mine?
No, sir.
I object to this as not being relevant to this application.
I think it's relevant in the sense that we're trying to establish who has the right to do venting and who has the right to manufacture and produce gas, which is a relevant issue in these proceedings.
So the venting is not a part of this pooling application, so you may ask a question regarding the production of gas relevant to this.
I'll rephrase the question. Other than the right to vent the coal mines, does the coal lease give Coronado any right to produce and market gas from Buchanan Energy's property?
No, sir.
Does the coal lease give anyone the right to search for and remove gas from the Buchanan Energy property?
No, sir.
Objection relative to relevance. Move off the coal lease.
We have also presented to the court, and Diversified has just moved into evidence all their exhibit 1, which I'm showing to you now. You recognize this document?
Yes, sir.
What is it?
It's the coal bed methane lease between Buchanan Energy and Diversified.
The lease originally was not between those two parties. That's correct. And so Buchanan Energy, is it the successor to the coal lessor?
It is.
I mean, to the gas lessor?
Yes.
And Diversified to the gas lessee?
Yes.
When was that lease put into effect?
In February the 1st, 1999.
And has there been production on that lease in the intervening years between 1999 and 2026?
Yes, sir.
Is the lease still active and in good standing?
It is.
Who does the lease give the right to drill, remove, and market coal bed methane from Buchanan Energy property?
Diversified.
Is that right to be shared with anyone else?
No.
What is the royalty rate under that lease?
I object to this as the relevance of this.
I believe we can show that. What is the?
Have an objection here? Can you
Yes.
address the objection?
Yes, I believe the terms of the lease and the royalty and the downstream charges are a matter that we have addressed. And I'd like to get them on record to show that I'm struggling for the term that you use here, compulsory pooling order, the lease imposed by that is different. And that's all I'm attempting to do at this point.
You want to respond to that, Mr. Swartz?
I think it's probably more efficient to just withdraw my objection and let's move on.
Thank you. What is the royalty rate under that lease?
It's 1/8.
I would like to direct your attention to page 9 of the lease. And with regard to the payment provisions, and there is a sentence there that I would like for you to read to the board.
In the case of coal bed methane gas not sold at the wellhead, lessee shall not deduct from royalty any sum from the sales price at the point of sale, including but not limited to deductions for gathering, transportation, line loss, compression, taxes.
Has Buchanan Energy granted to Pocahontas the right to drill into its property to recover gas for marketing?
No, sir.
Does Pocahontas have any implied right to use Buchanan Energy surface to recover gas for marketing?
If they were a contractor for Coronado to drill a vent well, but a vent well.
Yeah. Is Buchanan Energy willing to allow Pocahontas to drill through its surface or otherwise use its surface for the production and monetizing of gas property?
No, sir.
Why not?
That is an exclusive right given to Diversified.
Does Pocahontas have any right to operate on Buchanan Energy surface except for the purpose of drilling ventilation wells?
No, sir.
What's the effect of Buchanan Energy being forced pooled and having the compulsory pooling order applied to them as being deemed leased? What effect does that have on Buchanan Energy?
The loss of our contractual rights associated with the lease and the loss of revenue associated with the downstream costs.
that would be deducted from a royalty.
I have no further. Have any redirect, Mr. Schwartz?
Yes, what is the page number of the royalty provision that you've been talking about in your lease?
I've closed my lease. Let me pull it back out. It's 9.
Okay, actually, I guess it's at page 8, the fourth
Start today.
royalties. Do you see that?
Yes.
Okay, the first the first sentence of that says, lessee shall pay the following royalties, and I'm going to read it, just, my question is going to be, have I read it correctly? Lessee shall pay lessor on coal bed methane gas produced from the premises and sold or used off the leased premises or in the manufacture of other products therefrom, the general wholesale market price at the well. Have I read that correctly?
Yes.
Do you understand that gas does not get sold, at least in the area that we're talking about, at the well? It gets sold at a sales point into a pipeline. Do you understand that?
Okay,
I mean, is that true?
I assume it is.
Okay. Would you agree with the fact that it costs money to get gas from a well to a pipeline?
I can't speak to that where I'm not a gas producer.
Well, let's use some common sense. To get the gas from the well to a sales point, you need to build a pipeline to get it there, right? You don't drive it in a truck. Correct?
Sure. Whichever way
And
you need to do to transport.
Okay, so in addition, do you understand that if you've got a pipeline with low pressure coal bed methane, you need compression to get it to move in that line?
Sure.
Okay, so do you understand as a general common sense matter that it costs money?
Standard for wellhead to pay at wellhead cost is whatever.
Not muted on the call. You'll mute yourself. Thank you.
I'll start the question over. Would you agree then that as a general proposition, using common sense, it costs money to get gas from a wellhead to a sales point?
Yes.
Would you also agree with the general proposition that the market price at the well is probably not the same as the market price at a sales point?
If you take a deduction, it wouldn't be.
I'm not asking you about deductions. I'm saying, would you agree that your lease says the general wholesale market price at the well? And my question is, would you think as a matter of common sense, or do you actually know that the general wholesale market price at the wellhead is probably lower than the price at a pipeline point of sale?
Well, in relation to our lease, that doesn't play into it.
I don't think you've answered this
What is
question.
it?
It's a
What is it
straight
that you?
question. It's a yes or no question.
I understand that, but I mean, I'm not a gas producer. All I have is,
Well, you are here as a knowledgeable witness of a gas operation, and you are oversee those operations on behalf of your client. You should know this as an answer.
sure,
If you don't, we need to bring another witness in to answer the question.
This is common.
sure. As a common sense approach, yes.
Okay. in a perfect world, would it be safe to assume that the difference in the price between at the well and at the sales point into a pipeline is probably accounted for in part by the cost incurred to get it from the well to the pipeline?
Can you repeat that?
Okay, I'll ask it a different way. Do you know whether the general wholesale price is lower than the price at a sales point into a pipeline because it costs money to transport the gas from the well to the pipeline?
I object to the relevance here. We have established contracts with clear language.
Okay,
That's my objection.
your objection, you want to respond to his objection?
I mean, this witness has been called to testify, if I understand his testimony correctly, that his employer will lose money if it receives a 1/8 of the price at a sales point into a pipeline instead of 1/8 at the wellhead. I mean, that's your position, and I'm testing whether or not that makes sense. So that's why I'm asking these questions.
And I don't think, Mr. Chairman, that it's relevant because it doesn't matter if it makes sense. The first clause that was read speaks to this. It says, in the case of coal bed methane gas not sold at the wellhead. Which is exactly what Mr. Schwartz is talking about. There's a specific contract term.
I think we're going around and around here on a issue that's we've established in the past, but if you want to rephrase your question or anything, Mr. Schwartz, that addresses what the witness has already testified to.
Okay, I'm going to try one more time, and then regardless of the answer, although God knows I'm giving him a permission to not answer, I'll move on. My question, sir, is, do you know if, as a matter of practicality, the amount of the 1/8 royalty at the point of sale is probably close to or equal to the market price at the well?
Don't know.
Okay,
That's it.
then let me ask you just a couple more questions. The Virginia Gas and Oil Board is not a party to your gas lease, are they?
No, it's between us and Diversified.
Okay. And Pocahontas Gas is not a party to your coal bed methane lease, correct?
That's correct.
Do you understand that if this unit is pooled, the pooling order would give Diversified the opportunity to participate? Do you understand that?
Yes.
Was that a yes?
Yes.
Okay. Do you understand that if Diversified elects to participate, they would be required by the terms of the lease you have with them to pay any differential in royalty under their lease?
Yes.
Okay, so if this unit is pooled and Diversified participates, there's no loss to you. Correct?
From the payments that Diversified pays to us.
They'd have to honor their lease.
Right.
Okay, that's all I have, Mr. Chairman.
Let me redirect, Mr. Pruitt.
Yes.
No, I don't. Do you have any further witnesses from Diversified or Buchanan Energy?
I do not.
Sure. I think we're done with all testimony for this application.
We're done.
Okay, questions from the board for anything they've heard today that they need clarification on? Not sure if we need to have a witness come back up, but I did want to clarify just a couple of things that I think may still be unclear to some people. We had a lot of discussion on the board's authority under the regulations to allow production cost. And I can't remember, if you correct me if I'm wrong, post-production costs. And under board regulation, VAC, these are board regulations, not the Act. VAC 25-160-100-2A, for the allowable cost, it does address, under the indirect cost, it does address operating and production costs. And I would infer that that includes post-production costs. That
We do not agree with that, and I will argue that for you some of them.
But I think that we didn't cite that regulation, I don't think, before. I think we were under the 1600 section before. I don't remember anybody bringing that one up. That's correct. Okay. I just want to make sure that that was on the record, that that is in the regulation of the board.
I respect what you're saying, but obviously take exception to that. And I'd also point out the provision below that, B as in Ben. It says when there are conflicting royalty claims, CBM gas, the unit operator to pull gas unit shall deposit proceeds in accordance with 1622 to be determined at the wellhead, which would seem to exclude post-production costs.
Okay, I'm not sure I agree with that interpretation either. So leave that to the legal experts.
And I guess you're excluding me on that.
I guess to respond to your observation, Mr. Chairman, I think that the regulation 160-100 allowable costs, which may be shared in pooled gas or oil operations, that does not apply to royalty.
Correct.
That's how people who have working interests share their costs. The royalty issue, and this goes back, some of you may remember, Mr. Harris may remember, the orders that we submit to the board for frac wells, for unsealed gob gas, those orders were actually, there were forms created by the board back in the distant past. And we use, Kelly and I, we use a board form to prepare the orders that you guys want us to submit. A lot of it's filling in the blanks and so forth. But the royalty provision in the orders that Kelly prepares and submits and that I review, the royalty provision in those orders was the board's decision and determination that that would be the provision you would use in your board orders to require the operator that you appointed to pay royalty. There are limited deductions that can be taken, not unlimited deductions. There are a lot of things they'd like to deduct, but they can't. But that was actually what you see us submitting, at least I can't speak for Diversified's orders, but at least what you're getting from us is the language from the form orders that the board adopted back in the 90s so that everybody couldn't draft an order that had to be put under a microscope every time you got an order. So, and to make that decision, the board took evidence and considered what's a standard royalty? The conclusion was a standard royalty pretty much is 1/8. So they were good with that. Then the board considered, okay, what would be reasonable deductions that an operator could take against the royalty, and what would be unreasonable deductions? And the reasonable deductions, the board concluded, are listed in that provision. So, it's not something that Pocahontas or CNX is creating a royalty provision. We are actually using the royalty provision from the board's form orders for frac wells, for if we had one, for unsealed gob gas. So that's where that comes from. And obviously, there's no provision in the board order with regard to allowable costs to be shared. That's taken care of by 160, 100 in the regs. I know it's a longer answer than you probably wanted, but I thought it would be helpful.
Thank you, Mr. Schwartz. Any other questions or comments from the board? Okay, we'll address these items as we did in the original hearings with the applications before. We'll move on and hear all the petitions. We'll meet with council, give us any legal guidance we need, and then we'll render a decision with 30 days. We'll move on to the next item on the petition. The next item on the agenda, a petition from Pocahontas Gas LLC for pooling under Oakwood coal bed methane field. Number 2, Unit F36, docket number BGOB 25-7154313. All parties who wish to address this matter, please come forward.
Question,
Mark?
Mr. Chairman.
Just a moment, Mr. Schwartz. What was your question?
Okay.
How does the board intend to address argument on these points? I know before we argued each point at the conclusion of the evidence on each unit.
I think we've gone through that. We've heard all the evidence at this point and had discussion and questions back and forth. I think that's the evidence that
we didn't understand. I didn't understand that to be argument because I told the board I had a specific reference that I wanted to cite to the board
regarding.
Y'all are maybe talking on different points here, thinking about evidence. He's talking about like lawyer summation.
Yeah,
argument.
Right.
Oh, did we have summations before, Ms. Cooper, on each of the applications that we considered?
Yes, we did. It would be a brief oral argument similar to like a closing statement. If parties wish to make them at the end of each petition, that would be an appropriate time. Or we could save them all to the very end if, they're going to be largely repeated. Or we could incorporate them like we did in the previous hearing.
This is
I don't
Schwartz.
have a preference.
I'm a big fan of doing it once.
Right. So we could have a summation at the end of all of it, if that's everybody at this point. Okay, you may proceed, Mr. Schwartz.
Got to locate my application, which will take me a second, and then I'll be ready. So don't run off in the wrong direction. We are on F36, correct? Yes.
Yes, correct.
Okay. All right. Kelly, would you state your name for us, please?
Kelly Berry.
Who do you work for?
I work for CNX Gas Company LLC, and I'm appearing today on behalf of their subsidiary, Pocahontas Gas LLC.
Okay, and this application pertains to the production of coal bed methane, unsealed coal bed methane gas from gob wells in F36, correct?
Yes.
What did you do to notify people that we would be having a hearing today?
We mailed a copy of the petition application to all respondents by certified mail with return receipt requested. And we also published notice in the Bluefield Daily Telegraph.
Did you file with the Division of Gas and Oil, your certificates with regard to mailing?
Yes,
And did you file the newspaper certificate with regard to publication with the division as well?
yes,
At this point, you've identified the respondents both in your application and in your notice, and there are a number of folks, including Buchanan Energy and Diversified. Do you want to add any people to the list of respondents today?
no,
Do you want to dismiss any of the respondents?
no,
Okay. With regard to your application, I think you set forth in there at paragraph 9, an estimate of allowable costs.
yes.
And those costs, if this were approved, are in what amount? Total.
Total $516,246.84. And that is the combined allocated cost for 18 and 19 East panel.
Okay. And that is the number that people who wanted to participate or be carried would use as the dollar figure to which they would apply their division of interest or percentage, right?
Yes,
Okay. The pooling request here is to pool under Oakwood 2
that's correct.
and to produce what kind of gob gas? Unsealed?
Unsealed coal bed methane gob gas.
Okay. And let's see here, you've got at PDF page 5, you have your plat, correct?
Yes,
And it's got a well with a slash through it. What does that mean?
that is a plugged coal bed methane well.
Okay. Currently, as far as you know, there are no producing wells in this unit.
That's correct.
Got behind your map, you've got tract identification, which includes surface owners to some extent, correct?
Yes,
Then we get to Exhibit B. What do you do there?
the Exhibit B lists all of the owners or claimants in the unit.
Then that would include people that you have leases from or other agreements, and to the extent that Pocahontas Gas or its affiliates own interest, that would also include the owned interest, correct?
Yes,
Okay, and then we come down to PDF page, I think it is 17. And we have an Exhibit B3, and what are we doing there?
the Exhibit B3 lists all of the unleased owners or claimants in the unit.
Okay, and that exhibit includes people besides Buchanan, correct?
Yes,
Quite a number of people, actually. If we come down to find Buchanan on B3, they're at the very last page, if I'm not mistaken, page 404, which is PDF page 20.
yes,
Okay, and at track 4, which refers to your plat.
yes,
Okay, and you've got 3 numbers to the right, well, actually 4 numbers, if you include acres, off to the right of Buchanan Energy Company LLC. And those numbers reflect acreage as the first column, but then we've got a division of interest in panel 18 East, right?
yes,
And division of interest in 19 East.
yes.
The percentages right under, and just let's stay with PDF page 20. The percentages right under the heading division of interest in panel 18 and division of interest in panel 19. What are those percentages?
Those are the percentages that the F-36 unit as a whole bears to those individual panels.
Okay. And that would be as a whole, meaning the folks that are unleased. Yes.
The entirety of the unit the percentage that the entirety of the unit bears to each of those panels.
Okay. And then the percentages associated with Mr. Ratliff, for example, is a much smaller number, and that's just his piece.
Yes.
Okay. Now, if we go down again to the bottom, to the page 404, PDF page 20, with regard to Buchanan Energy, they own a lot of acreage, according to your title work, in the 80-acre unit, right?
Yes.
How many acres total?
59.8.
And as a percentage of the entire unit, what's the percentage of those acres?
74.75%.
Okay. Now, if we look at the acreage that Buchanan has in the 18 and 19 panel, that would be the next two columns, correct?
Yes.
And what is Buchanan, in spite of the fact that, strike that, what's Buchanan's interest in the entirety of panel 18?
1.1685%.
Okay. And what's their interest in the entirety of panel 19?
2.3204%.
And those numbers are slightly less than the numbers at the top of the page, indicating
Yes.
that the difference is the other folks listed above, right?
Yes.
Okay. And then to recap, what is the total acres, strike that. It's to recap then, in spite of the fact that Buchanan Production owns 99.7240% of the unit, the acres in the unit, because of the way their acreage is situated on the ground, their interest in the panels is tiny, correct?
Yes.
Okay. And if we come to the next page, which is PDF page 21, Mr. Ball's already testified that this is an exhibit that he completed to get an average well cost for these wells, correct?
Yes.
This is the same exhibit that he's previously testified to, which shows a grand total well cost of what amount?
$753,344.
Okay. And then the next exhibit, you take the PDF page 22 is an exhibit that I think we refer to as Exhibit M. What have you done here?
Exhibit M reflects the percentages that each panel within the unit bears to the panel as a total for each 18 East and 19 East panel, and multiplies that percentage by the total estimated cost of all of the gob wells to be drilled within each panel, and comes up with a total allocated cost for unit F36 in each 18 and 19 East panels.
And F36 is actually the first one listed in 18 East, and that's 1.5668%, correct?
Yes.
Okay. And the cost allocation is simply multiplying 1.566.8 times the total cost, right?
That's correct.
Okay. And then you've done that also for 19 East,
Yes.
and you've highlighted in yellow the result of applying the percentage of the acreage times the dollar amount for each 18 and 19 longwall panels, and you've given us a grand total at the bottom, which you've already read from your application, correct?
That's correct.
Okay. Then with regard to the next item, you have this is PDF page 23. What is this?
This is a plat, the unit with the mining projections overlaid on top of the unit.
And there's a difference in the, well, there's red lines and there's black lines below. What's the difference?
The black lines are the development that's been completed, and the red lines is the development that's not been completed yet.
Uh, to the next item is the order that you've submitted.
Yes,
Okay, and that's something we're required to do.
yes,
Do you have a template that you use for this?
yes, we do.
What's the source of that template?
The Virginia Gas and Oil Board.
Okay, and if we come, and does their template have blanks?
Yes,
For example, paragraph 1, you need to put in a hearing date. Right?
yes,
Okay.
yes,
Another example, you and I have already talked about this. We don't have any dismissals, but sometimes we do.
yes,
And then if we keep coming down to, this would be PDF page 27, kind of in the middle of the page. There's the paragraph that starts, the formula or division of interest for production from any 80-acre drilling unit affected by a long wall panel, and from any, there's an extra semicolon there, separately owned tract in any such 80-acre unit shall be calculated as follows. And they've got a paragraph 7.2 for unsealed gob gas.
yes,
And it tells you how to make that acreage calculation to compute the division of interest in an unsealed gob gas panel.
yes,
Is the language that you and I have just been talking about, the formula for division of interest, is that word for word from the board's form order?
yes, and it's also word for word from the Oakwood 2 board order.
Okay. Your opinion that if the board were to enter in this order pooling this unit, and we take that together with the lease interest or acquisition interest that Pocahontas Gas has, albeit a small one, that the correlative rights of all of the owners of coal bed methane gas in the panels would be protected and royalty would be paid.
Yes,
Is the drilling of multiple wells in this panel or in these panels an accepted way to produce unsealed gas and assist in degassing the mine?
Objection to the
Yes.
leading.
sorry.
Objection to the leading.
Did you hear the objection, Mr. Forrest?
Yeah.
Be raised.
Okay. How many, can you give us some idea of how many wells your company has that produces unsealed gob gas following the same methodology that we've discussed today?
Mark may not have heard, but there was an objection to the last question.
Right, I'm asking a new question instead.
Oh, you're rephrasing.
Right.
Pardon.
Do you have the question in mind, Kelly?
But an estimate would be in the hundreds to perhaps thousands.
Okay. And what is your recommendation to the board with regard to the royalty provision?
A 1/8 royalty and the basis of a $5 per acre lease based on a 5-year paid up lease.
That's all I have, Mr. Chairman.
You have cross-examination to witness?
I do. Ms. Berry?
Yes, sir.
Your attorney has repeatedly stated that under the Oakwood rules, we pull by the unit, not by the panel. You agree with that statement? We pull, for long wall panels, we pull by the unit, not by the panel. That's why you're pulling or attempting to pull a particular unit, right?
Yes.
Okay, and in this unit, which is F36, what percentage of the acreage of the 80 acres does Pocahontas Gas or CNX control through a lease?
0.276%.
0.267%?
0.276, yes, sir.
That's, it's been a long time since I've been in handled percentages like that. That's basically a little over 200ths of 1 percentile, right?
Yes.
Said, well, what was your estimation of what Diversified controls compared to the 200ths of a percent?
I believe it was 74.75%.
And do you project a well, gob well, to be placed in any part of F36 in order to drain panel 19?
No,
You project a gob well in any part of F36 to drain any part of longwall panel 20?
no,
And the same
Yes.
answer on 18, right? So
correct.
in your application, you made a point to say that, I guess you recited that there used to be a frac well in F36.
Yes,
Was that a frac well that was originally permitted probably by GMAT?
I believe so.
It was pooling application and GMF was designated as the operator of that unit.
Yes,
And then at some point in time, that frac well was plugged and abandoned. Is that correct?
yes,
And then by virtue of the plugging and abandonment of that well, the original pooling order, you say, expired, correct?
that's correct.
Had that well not been plugged and abandoned, then that original pooling order would not have expired. Is that true?
That's true.
Mr. Chairman, I assume you want us to incorporate as much of the prior testimony as we can. Okay. Thought that was a safe bet. So With respect to that, I would like to incorporate all of Ms. Berry's, cross-examination testimony and the exhibits that we introduced on 37 and the proffers that we made. Unless for any reason their testimony was changed insofar as it concerns F-36. And if we can do that, I don't have any more questions.
Is that acceptable, Mr. Schwartz?
Yes, there is a there is a difference.
Let me interrupt you real quick, Mark. I'm sorry to do that. I was just told correctly that I misspoke, and I meant to incorporate all the stuff on E38, 37. Obviously, we haven't done E37. Anyway, go ahead, Mark.
Okay. A difference between E36, which we withdrew the petition, and F36 is in the B3, correct? In terms of
Yes.
how many folks are involved. Is Buchanan production in this unit, the F36 unit, the only party that we're seeking to force pool?
No.
In fact, Exhibit B3, which starts on PDF page 17, I think, I need to make sure.
Yes, it does.
Okay. It lists people who are being force pooled for, I don't know, 4, 5, 6, 7 pages. In
Yes,
addition to Buchanan Energy.
that's correct.
In E36, the only person that needed to be force pooled in that panel was Buchanan Energy, correct?
Yes.
And here we've got a whole host of other people.
Yes.
Okay, that's all I have, Mr. Chairman.
So we're going to incorporate everything. I don't have to worry about all that. And then I guess the questions I asked Rocky Stillwell about.
Well, he'll call his name. He's presenting
That's
his.
right. That's right. I'm sorry. So we're going to have to close up. Give me some coffee. Sorry.
Okay, Mr. Schwartz, you may call your next witness.
Mr. Chairman, I guess I need to also do the same.
Okay.
I'd like to incorporate previous questions, Ms. Berry, and her answers.
Well, as long as we're incorporating wholesale, Mr. Ball's testimony with regard to costs, applied to all of the units that are on the docket today. I'd like to incorporate his testimony. Mr. Braden's testimony with regard to the recoverable reserves in 18 and 19 apply to this application as well. I'd like to incorporate that. And Jonathan's example of panel allocation also would apply. I'd like to incorporate that as well.
Okay, all those will be incorporated. Do you have any specific testimony that needs to be addressing the application for E38 from any of those parties? Other than what you incorporated?
I think we're on F36, right? Okay, so if I incorporate the testimony of those three witnesses, Ball and Braden and oh my God, what I missed.
Mr. Belcher.
Mr. Belcher, right. I think I've touched the bases that I need to touch in addition to Kelly, because their testimony would be the same.
So he's incorporating his prior witnesses. Need to examine any of his prior witnesses with new questioning or specifics to this application.
I do not need to call anybody else if that's incorporated, and I finished with my examination and redirect to Kelly, so I'm done.
Okay. So I'm asking Mr. Street and Mr. Pruitt now if they have any cross-examination of any of those witnesses specific that wasn't covered in the incorporation that they need to address?
No, to the extent I cross-examined any of those folks, which I'm not sure that I did, I would ask that cross.
All that cross being incorporated, same.
I have no problem with incorporating.
So we've had testimony, cross-examination. Do you have any final thing at this point? Or we can take questions from the board now? We'll do a summation after we've heard all the cases, all the docket items.
I'm concluded with my presentation on this unit.
Okay, you've concluded. Okay. I did just have one question from Ms. Berry. Did you provide the total panel acreage for 18 and 19, which was used to do your calculations? I don't believe it's provided on the exhibit end. Do you have that total acreage of the panels so we can compare them when the competing application comes up?
I do have those acres. Did we provide those previously, Mark?
I don't think you generally provide that in your testimony.
We have them, if you give me a moment, Mr. Chairman, I saw them this morning.
Yeah, I was thinking that in the previous testimony, that we had provided exhibits that showed the total panel acres.
We've been talking about the panel for panel 20, but not 18 and 19. Which that's not on the wrong docket item here. We're on
No, I'm
36, right?
I'm just referring to the previous testimony when we had our hearings regarding F-37 and F-38.
Okay, 18 East, Mr. Chairman, I believe, and this is from exhibits that we used last time we had a hearing, but our 18 East map that we used was 201.05 acres. Okay. And 19 is 171.38 acres. And give me an example of what we provided in that regard. Let's see here, here we go.
I can pull those up if you would like for me to, Mark.
Yeah, if you
map?
can't, if you can, just either one of them, and we can show them what we did.
Certainly.
Okay, there is an example of, you see 18 East sort of in the middle there, Mr. Chairman?
Yes.
Okay, and then off to the left, we've captured all the acreage in there, and we've added it up, and it's so the total acreage that we have for that unsealed but isolated area is the 201.05 that I just reported to you. And then with regard to, we provided the same information with regard to 19. And that was 171.38, I believe, Kelly.
Yes.
Okay. That's what I needed. That's the number I was looking for.
All right.
Then the other question, you touched on it in part of your testimony with Ms. Berry. In your PDA page 27, where you touched upon the well types and the formula for division of interest. Ms. Berry, can you just briefly talk about the 4 different types of wells that you've indicated here and whether they will be applicable to this specific application and how production will be achieved for each of those type of wells, starting with the short hole gas?
Right. The short hole gas, those are not applicable here, but it would be for the unsealed gob gas, 7.2. The total acreage of the unit is, platted on the surface with the mining operations. And when the mining begins, then your gob area is created, and that is when the production would be allocated based on the percentage that each 80-acre unit would bear to that panel as a whole. So you're paying all the owners in each unit that intersects the longwall mining.
But the
So those
important,
gob gas will be the 16 wells in 18 panel and the 14 wells in 19.
Yes,
panel.
sir. Yes, sir.
to get paid in an 80-acre unit, your acreage has to be, in addition to being in the 80-acre unit, it has to overlay the unsealed panel.
Correct.
And then you see, get that number, which is, smaller than the entire interest usually, and you apply that to the production that you get from Mr. Belcher.
I was just trying to get at whether all these types of wells are going to be applicable under this application or not. If we had any well located in the longwall panel, which would have included a CBM well that's now been plugged, so that's not applicable, correct?
Correct.
And then there are no frac wells. That would be the same thing. That would be an existing frac well that's no longer there, that's been plugged. So it's not applicable to this application.
Correct.
Now, the short hole gas, can you explain how that gas is produced? Or is that going to be applicable here? We're not going to produce the short hole gas associated with this long wall panel.
It's essentially the same calculation and method that is used for unsealed gob gas.
I understand that, but will there be short hole gas produced associated with this panel?
I don't know if that's a question I can answer. It might be a question for Mr. Ball.
Josh, are you still on the line?
Yeah, I mean, I don't have that information. It's not that I'm unwilling to answer. We don't typically talk like short hole gas, short hole wells a lot. But I mean, if it's something that we need to know, I can try to find out, but I don't have an answer for that either, honestly.
Let me bring in Mr. Boyd here with the staff. Can you explain how the short hole gas is supposed to work to the board and how it would apply in this application?
Typically, what the short hole gas is, it's horizontal. Like a 2-inch hole is drilled back into solid coal seam. And then that's piped underground. So these are horizontal holes that goes back into the panel, back into the coal seam. Correct. To there before it's mined. It's piped underground to a location and then it comes out. It's piped up. There's a connection inside one of the vent shafts and a pipe there. All that gas is going to come out and come to the surface and it's metered at one central point.
So is that going to, is there going to be short hole? So the question is, will there be short hole gas produced as part of this cooling application? Will there be horizontal drilling within the mine where Pocahontas Gas will collect that gas and bring it to, and it will be brought to the surface where they will move it into a sales meter point?
Yeah, I guess I should have said it better on the front end. I don't think we have that information right now. I don't have that information. I would have to find, I know how the short holes work. I know all the intent of the engineering and everything behind it, but that's not something that we regularly communicate on the planning and development of short hole zone because it's drilled by a separate entity altogether from an underground basis. Unless Jonathan Belcher would know. I don't have that information. Jonathan, do you know anything about short holes on 18 or 19?
There. No, I don't. We just get that information from Coronado, as it happens. And, I allocate according to what they have. So we don't have any.
I think Mr. Boyd just stated that Pocahontas Gas was measuring that gas as it's produced to the surface.
Yes.
Yes.
You'll have, is that the common practice that it is short hole gas is produced on every longwall panel as the mining progresses?
That is correct.
So that gas has to be accounted for, correct? And it has to be, that gas is just mixed in with your normal production.
Yeah, just from a
Yes.
from a different meter point. Yeah.
Okay, I just want to clarify whether that was applicable to this application or not, and it sounds like it is applicable.
Okay.
Correct?
Yes.
Fiction to the leading.
Okay, just to clarify, do you have any questions on this matter?
I do have a couple of questions. Maybe Mr. Ball could answer this. You said the short holes are done by another entity. Is that Coronado that would be doing short hole drilling?
It is. Yeah, it's something they handle completely of their own underground. I couldn't even tell you who the contractor is that does it. They coordinate it, plan it, execute it all in-house. We don't really have anything to do with the execution of that.
And I don't know if this is your question or not, but the costs of the short holes, those are not passed along to the Oakwood 2 formula. Is that correct?
That's correct.
Mr. Chairman, the only thing that the division permits is the collection point itself, at the sales point. We don't have anything to do with the underground part of it. Right. It's just that.
But the gas is accounted for, and that's where it's accounted.
Reported to us, yes, sir.
Yes.
Reported. Any other questions from the board? Okay, we're ready to move on to the next docket item. This docket item number 6, which would be, let's see, are we on 6 or 5? Item number 6, petition for diversified production for pooling order, Oakwood 2, low bed methane gas field number 2, unit F36, docket number VGOP 25-1021-432. All parties who wish to speak this matter, please come forward. What's the order here? We'll start with testimony diversified and their witnesses.
Right, thank you, Mr. Chairman. You don't need to re-swear with Mr. Stillwell, right? Okay. Mr. Stillwell, will you state your name for the record?
Robbie Stillwell,
And by whom are you employed?
Diversified Energy.
Can you tell us a little bit about Diversified and their work here in Southwest Virginia?
Yes, how we acquired this asset right here is Diversity Summit, up for sale, Diversified bid it, was able to get this acquisition from Summit. That's how we acquired the Rogers lease. We operate several conventional wells and CBM wells in the Appalachian region in Virginia. We have several CBM wells and other projects.
And what is your title at Diversified?
I'm a EHS specialist.
Are you familiar with the application that we filed on behalf of Diversified? Okay, who is the applicant?
Diversified Production LLC,
And the current application for the board is the production for what type of wells?
coal-bed methane, God well.
And is Diversified authorized to do business under the common law?
Yes,
Is it registered with the Virginia Department of Energy and the Division of Gas and Oil?
yes,
And does it have the required blanket bond on file?
yes.
And what did Diversified do to notify the respondents, those interested, that we're going to have a hearing today?
Mailed out notification by certified mail and published by the Bluefield Daily Telegraph.
That was certified mail return receipt
Yes,
requested? Okay. And have we provided proofs of mailing and publication to the
Yes.
division? And is there anybody that we need to add or dismiss to the respondent list? What percentage of interest in Diversified have they acquired in this unit?
74.5575,
And what percentage are they seeking to pool today?
25.4426.
And this is an 80-acre unit, correct?
Yes,
Okay, so if we're gonna turn to the plat real quickly, and that is on board, page 8, it looks like, 8, 9. All right, so the plat here in the application is, a plat of the mineral owners and surface owners,
correct.
is that correct? Okay, and how many wells are currently in this unit?
Previously, the Rogers 419, that was, I helped drill several years ago. And it's requested, mine when they was, then a well was plugged.
Okay, and that was a Summit did
Yes,
that,
Summit, previous owner of this well.
and when was that?
7/9/24.
Okay, the plat we're looking at that has been submitted to the board, was that exhibit certified
Yes,
by whom?
Richard Bailey, land surveyor,
Okay, and Richard Bailey, he certified the tract identification,
correct, yes.
okay, and the acreage there. Okay, let's turn to exhibit B for the board and the one line that starts on page 13. Okay, the exhibit B lists all the owners within this unit, correct?
Correct,
And all their interests.
correct.
And if we turn to page 17. To it. Maybe I can get to it, I'm sorry. Okay, if we turn to page 17, there is a percentage there. It lists the acreage owned by Diversified, and what acreage is Diversified on?
59.646,
What about the interest, the gas interest of Diversified?
74.5575.
And that's exhibit B. When it comes to exhibit B3, this is the list of all the owners that are unleased, is that correct?
Correct, yes, ma'am.
And on the bottom of those pages, it gives us a percentage. Long list, I apologize. It's on page 28 for the board, it's online. What percentage of the unit is unleased by Diversified?
The acreage is 20.35.
What about the gas interest?
Let's see, 25.44.
And each owner has been set out in this application, right? Just, we've shown the interest not only in the unit, but in the panel as well.
Correct.
Okay. And what is the, already asked you that. All right. Is there escrow required in this unit?
No, ma'am.
Okay. So that's why we didn't divide the exhibit E.
Correct.
All right. Have any further questions? You? No?
Well, I was gone for a little bit of that.
Yeah.
Jessica.
So what Mr. Street wanted us to ask is, how do you intend to produce any gas? Well, there's no wells in this particular unit, correct?
Correct. Yeah, 36.
Okay. So that was a trick question from Mr. Street. I think those are all of my questions for our witness.
you have any cross-examination, Mr. Schwartz?
Yes, Mr. Stillwell, when did you mail notice to the respondents that you're seeking to pool?
Let me ask my legal team here, because I'm not sure. I won't lie to you.
It would have been sent out the day of the application is what we said.
Okay, she said the day of the application,
And when was that? What day was that?
September 19, 2025.
Okay. And 9/19, you said?
Yes.
Okay. Have you mailed notices to the respondents more than once, or is that the only time that you mailed?
You repeat the question, please?
Yes. You've told me that you mailed your application and exhibits to the respondents that you're seeking to force pool on or about September 19th, 2025. And my question is, have you notified the respondents since then by mail of any changes?
Not aware of any, but I don't want to,
What?
no, as far as I know, we did not.
Okay. Are you aware of the fact that your acreage, your exhibit M was modified recently?
Yeah, that's kind of goes back to the panel 20 question, I guess. It's same question.
Okay, well, just get when you originally mailed to people, your exhibit M had 254 acres, 254.35 acres in the 19 East panel. Is that correct?
I don't know.
I think Mr. Schwartz, we are going to have someone here to talk about panel. And I just think he's unfamiliar with the exhibit that you're referring to. We have another witness for that.
Okay, is there someone here that I can eventually say, what was the acreage on the 19th when you mailed compared to what it is now?
Yes, Mr. Schwartz, I'm going to call Mr. Cook and he will answer those questions for you.
Okay, well then I will let Rocky off the hook on that one. And actually, I think that's all the cross I have.
Can you redirect to the witness? We call your next witness. Yes.
Mr. Cook, good afternoon. Would you say your full name for the record?
Travis Coop,
And by whom are you employed?
Diversified Productions,
What is your title with Diversified?
Vice President of Upstream Operations for our Southern Division.
And did you participate in the preparation of some of the exhibits of this application?
Yes,
Okay, and Diversified has leased 74.5575% of this unit, correct?
yes,
And you heard Ms. Berry testify earlier that Pocahontas has leased about 1/4 of 1% of this unit, correct?
yes.
So Diversified has leased the majority of the interest in this unit. Correct. How many wells do you plan on drilling this unit?
None.
Did that plan change?
It could.
If God wills are put in this unit, is Diversified capable of producing gas and wells?
Yes.
And there have been question prior proceedings regarding the relationship with Coronado. Can you explain how you come to be connected with Coronado?
Yeah, Coronado reached out to us because of Kennedy.
And so you've worked with them for a while since then?
Yes.
And do you believe you can reach an agreement with Coronado if we become an operator in this unit?
Yes.
And so we're gonna turn here to some of the well costs. It's Exhibit C.
Yes.
Grab the page number. Now you signed this exhibit, correct?
That's correct.
It's on page 29? Is that correct? Okay. What does this sheet represent?
It's a well cost estimate.
And how many wells do you anticipate in F-36?
0.
You said 0? And what's the estimate for well cost for your application?
715,677.
How did you calculate?
We met with the contractors and they provided estimates.
How was the able to see an excess?
It is less than CNX.
And do you know why that is?
I mean, we met with the contractors and they gave us estimates.
Okay,
And that's the price that we,
so you met with some service providers in the area and they gave you that estimate? You think
Yes.
that's a fair estimate of what the cost might be
yes,
because of your conversations with these service providers?
yes.
Okay. And this cost is cost per well, correct?
It is.
Let's turn quickly over to Exhibit M as well. Let's talk about that for a moment. Now, the Exhibit M is a cost per panel, correct?
That's correct.
Well, let's start at the top of the exhibit. We'll start with 18 first. What is the acreage per panel of 18? Of this exhibit?
I had 36 and 19.
The total acreage per panel. So at the top.
The acreage panel is 280.57.
And DEC, that's diversified, correct?
That's correct.
And so if we're looking at this exhibit, DEC is diversified and others, anybody else other than diversified, correct?
That's correct.
Okay, so how many Oakwood units are affected by these two panels, 18 and 19? Versus 18?
Units.
Yeah. Okay. And what percentage of panel 18 crosses a unit at F-36? Look at F-36, what percentage of that panel?
6.
Can you say that louder for?
3.61.
And the total alcohol cost in panel 18? Share with us that.
The total cost is $12,600,513.
What about an F-36?
F-36 is 454.
And you've broken that down in this sheet. Estimate capital for diversified and estimate capital for other, correct?
Yes.
And can you give me what the estimate capital for diversified is?
F-36.
Hmm.
54.
Okay, or what about the other? No, okay, so I'm looking at the estimated capital for DEC, I'm sorry, for diversified, right here in F-36.
Oh, 335, 469.
Right, so what is attributable to others?
119, 443.
Those are the people we've listed in Exhibit B3, correct?
That's correct.
Okay. And then if we turn to 19, which is 35, page 35, what about the acreage in that panel? The total acreage in the panel?
171.6.
Okay, Okay, and then F30 and F36, was the acreage in the panel unit there?
Acreage in the unit, the percentage,
Well, let's do the acreage first.
total acreage,
Acreage in the panel unit is,
5.27,
and then the percentage.
3.1.
And so what is the total estimated capital for the panel itself?
Total estimated capital for the panel. 9,605,137.
What about for this unit? What is the total estimated capital for F36?
219,851. F36, 219,8.
What are the total?
So the total, oh, I'm sorry, 295,327. That's really hard for me to see.
I know it's small, we need to make it bigger. The estimated capital for diversified is what? How's that 295?
219,858.
What about for others?
75,468.
And again, those are the people who listed in B3.
That's
That's
correct.
what they would be responsible.
That's correct.
Okay, so Mr. Schwartz has asked about the difference between this and this acreage panel. Do you know why it has changed to 171 from our prior application?
Yeah, we didn't include the ventilation area on the second.
Now if we turn to plat L. Which is. I'm going backwards. Page 30. That's exhibit L. Is this an accurate depiction of where the panels are projected to be?
Yes,
Was this provided to you by Coronado?
yes,
Okay. And this was certified as well by Mr. Bailey?
yes, it was.
And he's a licensed land surveyor, is that
Yes.
correct? Okay, we submitted a proposed order of how we were gonna pay in these units, correct?
That is correct.
Think of anything else, Ben, that I think those are the questions I have for this witness.
If cross-examination, Mr. Schwartz.
Yes, get an exhibit up here. Okay.
Yeah. Stick thing.
Can you all see this? On your big screen?
Yeah, if you may want to zoom in a little bit if you can, possibly.
Okay, let me see. Really think I can zoom in on that. Is it just completely unreadable?
I think we get the gist of it. Is this the same one that's in the application?
Actually, the first one that you're looking at is F36 that was on the table on October 25th at that hearing. It's the Exhibit M for 19 East that Diversified filed in September. And the only thing I'm really interested in is, can you make out the acreage in the panel, which is Diversified told us was 254 acres, 0.35. Can you make that out? Do you see that?
This is panel 19.
Right.
Yeah, I think that's what was originally proposed, correct? And they've changed that today.
Okay, okay. So when you changed it to the, now the next thing is, wait, let me do a view here, rotate. Okay, this is what you gave us recently and what you're using today, and this is 171.40 acres, right?
Yes.
Okay, and is that 171.40 acres, does that come from our map, which is the next exhibit?
I don't think so.
Well, you have 171.40, and we have one, if you total the acreage on this map that's on the screen right now, it's 171.38. And you're saying it's just a coincidence that you're 171.4 now.
I assisted with this, but I didn't do all of the work. So for me, no, I did not look at this and then change the number myself. I did not.
Well, do you know if somebody just used the exhibit we're looking at, which is our exhibit, to get the total acreage in 19 East that you're using today?
I have no knowledge of that.
Okay. Do you have knowledge of how you calculate? Let's go here. Flip this view. Do you have, whoa, that's not what I wanted to do. When you calculate, this is from the October 21st packet that we had. When you calculate the interest in the panels, you're calculating the tract of like Buchanan here, tract number 1, and you're saying out of the total tract, the 59.646 acres, there is 2.6915% of that in the 18 panel and 4.0261% in the 19 panel, right?
Yes.
To make that calculation, you have to take the acreage, the Buchanan acreage, and divide it by the number of acres in the panel, correct?
Yes.
And that's how you came up with Buchanan Energy's percentage interest, division of interest in 18 as 3.61%, and in 19 as 5.04%, correct? Is that correct?
Say that again. I'm sorry.
Okay. The way that you arrived at the 3.61% and the 5.4% is you took the Buchanan acreage that was in the 80-acre unit and was over the top of the unsealed panel, and you divided that Buchanan acreage by the total acres in the panel.
The 3.61 is the percentage of the panel in the unit.
Okay, so your answer is yes, that's how you did it.
That is the 3.61. It's the
No.
percentage, it's the acres of the unit in the panel.
Okay, what I want to know is, how did you calculate 3.61 and 5.4? Did you divide the Buchanan Energy acreage that was both in the 80-acre unit and over the top of the unsealed panel? And did you take that acreage number and divide it by the total acres in the panel?
I'm not sure. I'm probably not going to answer that exact question.
Well, we need an answer to that, because I believe that is how it's done. Are you telling me that's not how it's done?
No, I'm not telling you that's not how it's done. I'm just unsure. I'm just
Well, let
not
me-
sure.
Okay, well, let's look at the next one. So on October 25th, when your acreage in this panel, the total acreage in the panel was 254.35. These were the division of interest that you calculated for Buchanan Energy, okay? You agree to that?
The 3.61%.
And that was as a result of the panel having, at least in part, 254.35 acres, correct? Why is this so hard?
I don't know. I don't do this completely by myself. We have engineers, GIS experts that assist us.
Well, here's what's concerning to me. Look at the next page here. This is the Exhibit B from today. I mean, if you pull down the, pull it off the website, this is your Exhibit B that you're proceeding on today for panel 19, and you're seeing Buchanan Energy's division of interest in panel 19 is 5.4%. But your acreage has changed from 254.35 to 171.4, and you've got the same number today that you had back in October. And my question is, why didn't you revise all of the percentages under panel 19 when you changed the acreage in the panel?
I don't know the answer to that right now.
Okay, well, do you know the answer to this? Would you agree with me that every percentage you've got under panel 19 interest for everybody in this exhibit is wrong?
I have to review it. I don't know. I need some assistance reviewing the land. I don't know the answer to that.
Do you want to take a couple of minutes and review it so you can answer my question as to whether or not every number for the 19 panel interest is wrong?
We'll accept your offer on that, Mark, and so there's no confusion. Do you mind if he talks to the gentleman that was more involved in the F-37 application? Because that would be helpful to him, but I understand he's under it for a second.
If you
How about we
want
take a
to,
10-minute break? We'll take a 10-minute break and allow them to confer and come back and try to answer your question.
thank you.
I'm on a fluid pill. I'm making runs.